as just a wrong statement of law. So first of all, appraisal is a condition preceding. It's been a condition preceding for over 100 years.
Exactly.
Okay? And if you read State Farm Lloyds versus Johnson, which every fucking roofer's probably read, it's right there.
No, they haven't. No, they haven't.
Okay.
No, and that's the thing is they don't encourage anyone to inform themselves in any actual way that's going to give them any form of information that is usable. They give them these little nuggets of, hey, here's how you can try to argue for drip edge. Here's how you can try. You know, it's like, why am I fucking arguing for something that I know needs to happen every time? You know, all of this stuff should happen every time. I don't need, I mean, it's good to know all of that stuff to have the building practices in your handbook, but it doesn't, you shouldn't have to fight the same fight on every single claim. That's the whole point.
And my point to you is even if you're absolutely right, you shouldn't have to fight the same fight. But mine's a little stronger. Why the fuck are you even fighting in the first place?
Exactly.
You're under the misconception that if you just say it correctly, and if you fight the good fight, you're gonna change their mind.
Yep.
It's not about changing their mind. They don't have authority.
Mm-hmm.
They're told in certain instances, we don't pay this unless you have A, B, C, and D. That's the internal policy.
And A, B, C, and D oftentimes are, you have to have an attorney, you have to have a PA, and that's the thing. And that's the true condition precedent to coverage, Tom. If I got Tom Hamrick on a claim, then the insured sets that claim reserve a shitload higher than if it's Steve Millenberg on that claim, and that's not fair. That's not fair to anybody.
He's just, he's a, yeah.
Okay, so let me tell you the thing about John Wood. His dad is Don Wood, who's the owner of Suncoast Claims, right? So I have no issues with them, but the only thing that I have issues with is they're so up in arms about contractors potentially misusing, proofs of loss. But here's noble public adjusters in Florida who's screwing people out of hundreds of thousands of dollars, like $64,000 in tree removal that they got billed for, and like another $57,000 in mold mitigation. So there's on one claim $120,000 that they didn't include in a proof of loss, and it screwed those people out of it, and they're just kind of left with, okay, now I have a lien on my house and no way to get it paid because I've sworn via an assignment of benefits. And so my whole feeling is I don't think the assignment of benefits in Florida going away benefits anybody but the PAs, because then the contractor can't get an assignment of benefits, and then the PAs are the only one who can do it.
Well, first of all, the PAs, I don't know about Florida, but they don't have an assignment of benefits in Texas.
I know. But it doesn't matter. You don't need an assignment of benefits in Texas. Not if you know what they know, which they made sure that no one else did. That's my whole bone of contention is.
If you agree with me that the roofer shouldn't be arguing, not because he's not qualified, but because words won't make a difference.
Exactly.
It goes unsaid. But then why the fuck would you hire a PA on a residential claim? Why?
Exactly. You wouldn't. That's the thing, is they leveraged, the whole system has been leveraged to be impossible to get anything done without using an attorney or using a PA or using the appraisal process. But the appraisal process has been so obscured by guys that didn't want only to get paid a couple $100 for an appraisal. So what ended up happening is in 2005, a benign law came through that, the public adjuster was defined in Texas, although they existed for 50 years, and then the public adjuster is defined in 2005, and then in an 11-hour and 24-minute hearing filled with a lot of really important stuff, 3.5 minutes were in there that I had to search for an hour through that video to try to find where this bill was actually discussed. I ended up having to go back and look at the minutes and figure out where it was. And it was 3.5 minutes long. They snuck through the UPA bullshit in 2013. Really? It was 3.5 minutes, and there was nobody that testified in opposition. And then the guy said, and then the Guillen went back up there and said, yep, close. Only words, just close. The room was full of people on other unrelated shit, and so it was just a complete, deception of people, and nobody knew that it even happened, or especially not what the net affect would be. And now they're trying to move that to all of contracting, and even the damn roofers that are supposed to be the leadership, RCAT and NTRCA, they're getting backdoor deals from Badger, and so they're supporting these because they think they say they're in the interest of the consumer when they're absolutely not. That's not the way they walk the streets. The way they walk the streets is only 5% of people have a representative that is legally authorized to do what has to happen, okay? And so you can't tell me that doesn't need to change. And it's what pisses me off is they're trying to now grab the wheel so I can't convince people that we need to go to fucking the legislative sessions and make sure that although these bills are in semi-advanced states, that they've made it through the initial part, that they don't that they don't go all the way up. And if they do go all the way up, then we've got evidence of reaching out to the people who are supposed to know and supposed to do something about it, and that shows that they didn't do something about it. And then we can do something with that evidence if we need to. That's been my plan from the beginning. And there's Carl Isett, and I talked to the U.S. Hispanic Contractors Association's president yesterday. I can't even think of the guy's name, but they're down there, and they're trying to make things make sense, and they're at least trying to not get the registration bill through. And then I don't know if they want the PA thing to go to everybody too, but the problem is if that happens, then we end up the entire insurance restoration. Here's my major bone of contention. I posted it yesterday. The entire insurance restoration world is going to be under this law that is more than likely would be proven unconstitutional if it were challenged in that regard. But insurance was created to protect us if shit hit the fan, and it failed. Okay, PAs came around because of that failure, and then PAs created their legitimacy based on policy interpretation. And like you said, that's 1% of what appraisals are. 99% of disputes are cost, causation, and scope, which is what contractors did forever before that. Yep. And all of a sudden, and so it's your idea, and it's your, I would want to confirm that statistic so I could show people, like, what percentage of appraisals are related to what deal. But I mean,
I will simplify it for you. Appraisal can only be about causation as an initial matter, scope, and pricing. That's it.
So as far as interpretation of the policy, as whether coverage should be extended to this?
No, it's not. They're not. Okay, so don't conflate coverage with causation. I know they both start with C and they both sound the same, but they're not. Okay? Coverage has to do with whether or not the carrier is responsible, liable, under the policy for a covered peril. Okay, so it's about, so as I explained it, I'm sorry, I'm breaking this down in smaller bites.
No worries.
In a very superficial way, most trials that we handle have two broad issues. One, who's responsible, and if they're responsible, how much? Okay.
Yep. So are you where Steve got the, it's not, they've already admitted to coverage, it's just how much coverage?
Well, yes, but I'll tell you why that makes a difference. It has nothing to do with appraisal. Even if they don't, if they don't cop to coverage, right? If they say, well, this claim is not covered, which is what State Farm Lloyds versus Johnson was all about. Okay. So if you're ever going to read a case, that's the case you have to read and
to understand.
And that case is so powerful that every defense lawyer, his first thing is, you can read into that case whatever you want. That's hint number one. They don't like the case. The answer is no, you can't read into that case whatever you want. That case is kind of a roadmap for all the shitty things you people can and can't do. All right?
Okay.
So within that case, what it says is look, State Farm was trying to say, because we said it wasn't covered, They can't go to appraisal because in order for them to go to appraisal, it's not a coverage issue, it's a causation issue. But remember, causation is just a fancy word for me saying that's a covered peril.
Right.
So take that triad of thoughts, okay? Coverage is determined under most policies under the definition of we will cover the following covered policies. Hail, right? And they're saying this wasn't hail damage. So if I'm saying it's not hail damage, how can they go and appraise and say we disagree it is hail damage? Because they're making a coverage determination by determining what caused the damage. A causation finding often leads to the coverage, right? The causation finding is that was damage caused by hail. That's a causation finding, right? But that same causation then imputes over to the coverage side. Well, let's look at your policy. You've determined coverage because we've said that's not hail damage. You're saying it is hail damage. And here's what the Supreme Court said was look, if that's the case, that as an initial matter, okay, well, first of all, they very tactfully explained it to the parties. Look, idiots, we have causation both in the coverage section, liability, and both in damage. Causation is an element of both of those cases. So yes, we're not letting them decide causation for the purposes of determining coverage. But we have to let them do a causation finding for the purposes of damage. And so what they said was, if that wasn't, and all the lawyers, defense lawyers, they've changed 125 years of law, and the Supreme Court was kind of laughing at them, saying, if you couldn't do that, then you could never do an appraisal unless the roof was brand new. And they went on to explain why. Because every policy excludes wear and tear. And if you can't distinguish wear and tear, in other words, damage caused by wear and tear, then you can never do an appraisal.
Right.
And we've been doing these fucking appraisals for 125 years.
Yeah, exactly. So, you know, they've been doing it all along. Why is it now?
Well,
yeah, exactly. It was just the argument they were trying to spin.
Right. They were just saying, you're so fucking wrong. And then they also said, if we only let the consumer go to appraisal when you guys agreed to coverage, then essentially you're the gatekeeper. You only have to go to appraisal when you want to. All you have to say is, well, under our current investigation, there's no coverage, so sue us. And now this is where the plaintiff's lawyers have mud on their face. I always say, if both sides had thought about State Farm Lloyd's versus Johnson, not me, because my business is based around that very case, okay? But if the traditional policyholder lawyers had thought it through, which they didn't, they would have never brought State Farm Lloyd's versus Johnson. Neither would the insurance company, because they had a nice little racket going on.
Yeah.
Because then guess what? Every time they said it's not covered, we don't have to go, they would say, then fine, we're just going to sue you, which they wanted to do anyway. And they would turn to poor Mrs. Smith and say, sorry, I got to take 40% of your fucking roof.
Yep.
Right? And then they don't want to go. They don't want to go to appraisal. If you talk to Chip Merlin, they don't want to go. Okay. If you talk, look. I like Rick Daly. I've talked to him several times. He is a nice guy. All right. But flat out, they don't want to enforce appraisal. They don't like it. And here's the reason why. If you go to appraisal first and they pay the award, you don't get attorney's fees. You don't get trouble damages. Anyway, you see what I'm saying?
Exactly.
Right. Now,
well, one question: how long do we have? All right, so the appraiser has been named for the insured side on the one we talked about yesterday, and that appraiser reached out to him with a list of umpires. How long do we have to on the umpire stuff?
Okay. Well, first of all, you have to look at the policy. So usually the standard policy, to the extent that that you can now call a standard one, and you and I already had a discussion about how things became substandard when we used to only have 3 or 4 policies that were accepted in Texas. That's changed. So so you can no longer know what's in the appraisal clause because everybody can write it differently. But the standard, to the extent that there still is one, goes something like this. One side will pick its appraiser. That would be you. They have 20 days to pick theirs, right? So once they've picked theirs, those two appraisers normally have 15 days in which to agree upon an umpire, and if they fail to do it within the 15 days,
what does that normally mean? You said normally.
I'm saying
normally 15 days, depending on the policy language.
Depending on the policy. For example, some of them say they don't have to go pick an umpire until they've reached a disagreement. Some of them say they don't have to. They're not allowed to go pick the umpire. They have to go to the American Arbitration Association.
That doesn't say that. This is nationwide, so it says that they will agree upon an umpire, and I think it says within 15 days, but it may say that, okay, and so do you have a second where you can kind of just give me a quick walkthrough? There were a couple of questions that I had there. So we've got our appraiser and theirs, and then we've got now we've got to select the umpire within 15 days. If it doesn't specify the time frame, would they be able to drag it out ad infinitum, or how do you go about getting a judge to appoint one if we can't come up with a viable option?
So first of all, think of these things as not a statutory mandate, but they're a contractual clause. Okay.
Sure.
And you'll realize some things you can waive, some things you can't waive, but it's the whole thing of if either appraiser wants to tell their client about it, they just do a wink nudge of, hey, all right, I know the appraisal clause says that, but it says either party may, right? Which implies maybe it means they don't have to. That both parties can say, let's just wait another month. But if one party gets pissed and says, I'm going to invoke my right, even if the other party says, no, man, wait an extra 30 days, the other appraiser can call his or her client and say, we need to get an umpire appointed. Now, you'll also notice that it says you or we may approach a court of competent jurisdiction or a court of record or a district court where the property is located, or there's all sorts of, it tries to tell you which court. It doesn't always say district court. Sometimes it says a court of competent jurisdiction. Sometimes it says a court of record. Sometimes it says a court of record in the state. Sometimes it says a court of record in the county. That's why you got to read the clause. But the part most appraisers miss is it says you or we. Well, you and we, or the term you and the term we, are defined in the policy. You is defined as the insured. We is defined as the insurance company. The appraisers cannot go down and ask a judge under most policies. I have seen, look, there's thousands of fucking policies out there, right? I have seen an old policy that allowed the appraisers to go and do it. That's why you have to have the actual appraisal clause.
Right.
But normally it says you or we. Okay?
Right.
And if it says you or we, it's not referring to the appraisers. It's referring to the client. Right. So essentially the appraiser has to call the person that hired him. So he would call the client. He would then call the roofer and say, oh, I don't know why this fucker's calling me. This was your idea. And then you have to figure out how to go you can't do that on behalf of the client because then you're practicing law. So normally what happens is I get a roofer or a contractor calling me and saying, look, Mrs. Smith needs an umpire appointed. Mm-hmm. And I do it informally for $500. That's like if I just have to write a letter to the court and tell both sides, or I do it for it's a total charge of $1,500 if I have to get off my ass or if I have to have a conference call with the court. And I tell the party they can pay me once the construction's over, or once they get paid. The hard part about all of this is that I'll only do it, like if you say, hey, I need a judge appointed in BFE, I'm not going to do it. If it takes me 4 hours to drive to BFE, or even if it takes me an hour and a half to get there, I'm not going to do it. Because that's just 3 hours of driving.
Yeah, exactly.
It's just not cost effective. So what I would tell you is I'll help you find a local attorney there, And for free, I'll give them the fucking forms. It's just forms.
Yeah, exactly.
Okay? And if you read that article, where most lawyers go wrong, including Steve Badger, is it's an informal process. Informal means you don't go through the front door. But I also tell you, it doesn't allow you just to unilaterally knock on the judge's door. Okay, but that's for a different reason. That's an ethical reason. But anyway, so there are the fine nuances. But your question is well, then how do we get the umpire appointed? The first thing is if you pick a good appraiser, first of all, he needs to know all the pitfalls. Look, it's a small community. You know who the ringers are. So, and you know who your ringers are. And if you know who your ringers are, they know they're also ringers. So what happens is both of them, they send their ringers, you send your ringers. Sometimes they fuck up and they think they've got a ringer, but you've got a relationship with them. And when you show up, he's not a ringer. Okay? It's like reading fucking tea leaves. But the bottom line is even before you waste the client's money and run down to the courthouse, do not think for 1 second just because you hired a lawyer you're going to get a great ringer of an umpire. And I would tell you, if I'm hired, you're going to get the exact opposite. You're probably going to get a former retired judge who's been trained, or a mediator who's a lawyer who has no subject matter expertise but knows how to call the ball and will follow the best argument.
Okay.
So
training an appraiser versus training an umpire, that's a different process, Indy, huh?
No, I use the exact same
process, but just different
emphasis. Yeah. And so, speaking of which, I got a call yesterday from a guy. The second time in 6 months he's called me. He's a local contractor in the Dallas-Fort Worth area. And he said, tell me about appraisals. And I said, dude, last time I talked to you, I told you, you need to start training to be an appraiser, period. In addition to being a contractor. And Steve, I'll tell you the same thing. You need to go learn how to be an appraiser.
Well, I'm learning from the source here. I've created a friendship with the guy who knows more about the shit than anybody else, and I'm reading everything of his that I can get away with. My girlfriend is really helpfully making me shut it down a little bit, and I need to, because my business is going to suffer if I don't. But every chance I do get, I'm going to read every bit I can. So anyway, I said yesterday, so I've got people attacking me because I'm kind of going after PAs because of what they're saying. Well, John Wood pipes in, or this guy in comments on Ed Faco's post that says, poof, just like that, Florida stopped being the mecca of insurance claims, where Ed talks about the AOB going out of Florida. And I said the main thing was, and this is what I truly feel, the governor was pissed at the PAs and the contractors because they were swooping in these apparent total loss situations, and they were signing up these clients and attaching a 30% bill when they knew it was going to be a policy limit payout. And so that the governor made the insurance commissioner make a law that said they couldn't do that. Okay, and so that's why the governor's anti-PA and contractor right now. And then, curiously, now comes legislation to get rid of the AOB, which will completely disenfranchise all of those homeowners who had a chance with their contractor, could sign over their benefits, and somebody like me could go to fight for them. Now that can't happen anymore there. Who does that benefit? Fucking PAs. The Daniel Tigas of the world, the people that actually didn't show up and do a damn thing. They didn't care. And now John, and so I said that. I just said, knowing full well it'll be a claim on his payout, and the insured will pay them 30%. That's why the governor is anti-PA and anti-contractor there. I can't say I blame him in that case, but what he's not realizing is this was the plan. Pass carrier-friendly laws to turn record profits. Happened in Texas, not past this session, though. And John said, you evidently know nothing about the Florida claims environment. Stop attacking public adjusters. And then this other guy says, and I don't, I'm not particularly trying to attack them, but I'm just saying it's not like they're completely innocent. And honestly, if those guys here are in bed with the insurance companies, I got a reason to believe that they're in bed with the insurance companies there too. I mean, And to say that John Wood and Steve Patrick and Russ Wilson and Paul Ramon and all these guys aren't tied to Steve Badger, I mean, you watch on these forums, I got evidence of all of it. I mean, you see him talking, like, kissing his ass in public, and that's the thing that really set me off against them. One comment is, how I got a $10 million difference, and so I'm just sitting there in my head thinking, you got paid out $1 million fucking on one claim, and you sent emails? Like, fuck you guys. Like, that's what I was thinking, but then I also understand, hey, they probably did a lot better than that homeowner would have done on their own, or that property owner if it was commercial, whatever. I don't give a shit. They can have that. I just want to be able to have that for my people as quickly, or as, I feel like people should be able to learn whatever it is whenever, and so Ed Faco talks about this 3 years ago publicly. Why didn't he present this to everybody to use 3 years ago? It's because people told him not to. People said, hey, if they realize what appraisal is and that it shouldn't be so expensive, and that we're not able to just have the carrier's representatives read the appraisal clause as an intimidation away from using it, which is what has happened. It's been weaponized. The appraisal clause is weaponized because appraisal costs $1,500 to $3,000, and you told me yourself that the average American has $500. So we've committed fraud to waive the deductible, or to not pay our deductible, and now we've got to commit more fraud to go to appraisal. That's the way they have it set up.
Well, how about even worse than that? More fraud to pay your PA.
Yep, more fraud to pay your PA. Yep, exactly.
Who's PAs getting paid?
We've talked about this, and I know. Yeah, every bit of it.
All those funds, except for attorney's fees, that if you're able to get them awarded, come out of the contractor's pocket. But never forget, the client doesn't give a fuck.
Yep.
It's the contractor who's losing money.
Exactly. The client. That's why we can't get them. That's why they stress doing all the supplementing and all this shit on the front end, because they know we'll never get anywhere unless the work's done. Like, that's the thing that irritates the fuck out of me is, and so in order to protect ourselves and keep our businesses shielded from that, the way that you have to do it is kind of cunning, and it's what I've been telling people to do, is take the carrier's estimate. If it's enough for you, with, if you have enough money personally to float any deficits that are there in the interim, build it how you know it needs to be built. Build it to spec, build it to code, and then bill the consumer for it, and then make sure they fulfill their post-loss obligations. And then what's going to happen is, once they've sent in a sworn statement and proof of loss, the carrier invokes appraisal. Well, what I think should happen is, once the carrier invokes appraisal, if it comes back at 100% of what the contractor had, then that should be bad faith. If it comes back $1 higher, then all appraisal expenses should be the insurer's.
But that's a wish list of things that might or might happen.
Well, that's what makes sense for the consumer.
Well, okay, so let's talk about. So there were several. Look, and this is going to be hard to grasp. Unfortunately, for every statement about the law says this, there's always an exception. Right. Not always, but there's often an exception. So understanding the nuance of the situation is important. So under your nuance of look, if you think you've got enough to move forward, start and do everything, and then this thing of, then we'll file, we'll send them the bill. That's all good so far, and we'll file a sworn proof of a loss. That's great as well. And then all of a sudden they'll have to go to appraisal. The answer is yes, but no. The only time that you can do that, and I tell contractors, well, there are two problems with that. Number one, you can only do that if we're just arguing about cost. We're not arguing about scope. And by scope, I mean that I'm not talking about you don't need ridge valleys. You do. That's not. I'm talking about broad scope. Have they agreed that roof needs to be totally replaced? And you're fighting about what's it going to take? How does one replace the roof, and how much does it cost? Then you can go ahead and tear it off, and we can go fight about the cost later. But if they said all you can replace is one slope, and you tear the fucker off and you replace all the strokes, and even though you take pictures, you do everything perfectly, you run the risk that you've spoiled the evidence, and there's nothing to fucking appraise.
Exactly.
Right.
Well, so but that's my point. If a 10 out of 10, like that's the thing. If we can train contractors to have appraisal set up to be 10 out of 10, and a 10 out of 10 is a picture of every line item that's not an administrative or a something that's not something you can take a picture of item, then it's got a picture before, during, and after. Before, when the item was damaged, during the repair, and after the repair's been completed. And so if that's a 10 out of
that's not
why?
To save you.
Okay.
Because they're going to show up and say, for purposes of appraisal, we believe that you've prejudiced that because a picture's not good enough. I've got to be able to touch it. There's a tactile thing. I've got to be able to touch it, smell it, push on it, walk on it, feel it, taste it, whatever. And,
I can appreciate that, but you can see this, and this photo is time dated here, Tom. And so while I appreciate the necessity that you might have for touching something to make that seem more concrete to you, there's no denying that this picture was taken at this time on this date when this work was being completed. So I can't say that I agree with you that what they've done is any destruction of evidence. What they've done is gone ahead and gotten the insured back to their pre-loss condition in a reasonable amount of time because you guys refuse to account for this properly, or because the carrier has refused to account for this fairly.
Okay, if that was your answer in a law school exam, I'd give you a C.
A zero.
Okay? A C. I wouldn't give you zero. I'd give you a C. But you've missed the greater point of it is they'll also come and say we can't do any testing, we can't do any measurement. First of all, and more importantly, the judge will say, why the fuck did you do it in the first place? You'll say mitigation and blah, blah, blah. And you just raised a big old fat thing. And frankly, if you did it, I wouldn't take the case. There's just not enough. It's so fucked up that I can't take it on an hourly rate. Okay? Because if you're wrong, I don't get paid. And then I look at you and say, why the fuck did you do it?
Well, so that's the point is I've got to be willing to hedge that bet that the only, and so that's what I've done, Tom. Like, all of these claims, I'm okay with just taking what they've paid to this point and not a dollar more. I'm not letting my clients pay anything extra. I'm going after what should have been paid from the beginning and doing it in a smart way, but I'm not requiring, I'm not going to obligate the insured to pay something that their carrier fraudulently screwed them out of.
Well, then you got a second problem.
Well, I mean, the problem is the people know that I'm not going to make them pay it. That's the only problem.
So then you can never get your recoverable depreciation.
Well, I can because they know that I have lien rights, and they know that if they try to fuck me, that I'm going to lien them, and I file a lien,
So when Mrs. Smith shows up and I say, look, I know Stephen's a great guy, and he sat down, did he explain to you that if this appraisal fails and you don't get any more money, do you still owe Stephen money? And the answer should be no, because that's what you just expressed to me. And say, well, can you show me Stephen's contract? Before he agreed to do this work, what did he tell you he would do this work for? Because there's a basic premise of the document speaks for itself, and there can be no extrinsic or parole evidence to explain what that means. And if your document said, I'll do it for insurance proceeds plus supplement minus depreciation, blah, 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 then you're fucked. Because the insurance company
says insurance. Mine says insurance. I changed it after we talked, and it says insurance company, or it says carrier's estimated scope, and it puts the number, and then it says plus RTA value for work. Okay, and so RTA is defined down below as the real, true, and accurate cost of professionals performing all portions of this project as they are determined, which cannot be identified completely at this time, but will be within X amount of time. Okay, so then from the time that you provide your scope and cost to them, they have 24 hours to say, hey, we don't understand something, or hey, are you sure you need to do this? And if you haven't explained to them in a way that the project demands that work has to happen in that way, and you can't explain that, then they don't initial it, and you don't include it in your final or your preliminary final invoice. Then you send that preliminary final invoice in along with and then they send in their sworn statement and proof of loss, and then that that should be all of the information. If you've provided the full scope to the carrier up front, that should be all the information that they can ask for. They can't say, hey, we have to come back because, no, we told you the garage door was damaged on the first day. You knew we were asking for that. We told you that overhead and profit was going to be included on this on the first day. You know, there's no additional information y'all need.
All right, so you've like messed up a whole bunch of legal concepts.
What did I miss?
Well, okay, I'll list them.
Okay.
Number one, dude, when I talked to you, I told you to put in or including the appraisal award or judgment from the court. Okay, so and by the way, there's no such thing as RTA in an insurance contract.
Why?
It's not even because that's not the way insurance is set up.
Right, but I'm not. It's a construction contract. This is not an insurance contract. I'm signing a contract for a construction job.
Okay, okay. So Mrs. Smith, before the work is done, in other words, before consideration was already extended, agreed to the price of your thing. In other words, you supplied her the RTA before you started work.
Correct.
Okay.
Or at the time work starting.
At the time work starting, and she signed it.
And you're going over every line item with them as the roofers are ripping off the roof, and you have to be there anyway. You have to be there to make sure that you have to have an OSHA certified supervisor there. So whoever is the salesperson or the business owner or whoever it is needs to be OSHA certified, and they're on site, or you have a different person that's doing that. But for me, it makes sense that I'm the one who's certified and I'm there, and the roofer is certified and he's there. So as they're doing the pull-off, so here's the way it protects me, Tom, and this is the reason that I have decided to do it this way. As I'm ripping the roof off and the materials and everything are there, I'm going over this supplement with the people and saying, here's what this job should cost and here's why. On every item, you guys are going to agree with me, and I'm going to explain to you using their software how these prices per line item were calculated, per unit were calculated. But this is a unit pricing estimate for a job to be done, and I'm going to show you how they've deflated certain things to make us potentially obligated to only do this because they pay it that way. That's the only justification. There's not that it's not reasonable to do it that way, not that it's not legitimately done that way. It's just that they don't want to pay it that way. And so unfortunately, good business practices, building codes and laws and all these things that they've got this lie spun that you need extra coverage for, it doesn't matter. We have to do those things every time, and to assume that indemnification or indemnity doesn't include the required items is not really what I think people thought about when they thought about indemnity. So we have to...
I don't need to hear the sales pitch. I like it.
But that's what it is.
You didn't answer. Okay, my question is very specific. Before the work has started, is she told exactly how much she's going to be charged before you start the work?
At the time the work is going on, we're going over it.
Okay.
Does that create a liability?
Okay, so hang on a second. Yes, it does, because you have to give consideration. It depends. So what does it mean by at the time? Do you do this 10 times, or the day you start the job?
No, the day you start. So you've gotten the scope back from the carrier, and they've gotten their payment, and they've paid you a down payment. Okay, and the down payment is a portion of the ACV and the deductible. Okay, and so, or whatever that is. Okay, and so whatever your down payment is, or a contractor's down payment procedure, or whatever they do individually, I don't really care. You have to have dollars changing hands in order for that contract to be enforceable in my mind. There has to be consideration from, consideration for performance.
You're not answering my questions.
Well, so that I don't mean to be talking circles around it. I'm just trying to set the scene.
I got the scene.
Okay. So it's gone over with. So the insured at the beginning has agreed and has been told that you are going to provide an estimate at the time of the build. As they're ripping it off, you're going to be going over it with them because you have to be there anyway. And then it protects the business. So number one, you've explained to them what the process is going to be. And then two, at the time that it's coming off,
Stop. So you're telling me that as your men are ripping apart Mrs. Smith's roof, you're telling her how much it's going to cost. What if Mrs. Smith says, no, I'm not in, put these shingles back?
put the shingles back? Unfortunately, we can't put the shingles back.
Okay.
And we've signed a contract to do this work, and we've delivered the materials. I mean, we can't do that. And so here, that's the whole.
Agreed to the, but you've already. In other words, the court's not going to be happy about this, and they're going to be reviewing the process. So you're basically saying is, as I'm tearing it apart, I'm going to give you the final number. And the judge will just look and say, give them the final number before you start fucking tearing it apart.
But so it's an administrative cost, right, to create all of that work, or to create that estimate of time, and then it's an administrative cost of time to go over that with the client. Why can't you? How can there not be a reasonable justification for trying to combine some of the time instead of making that a separate time? Instead of making that separate.
You're assuming that you can't then sit and find their dude, get there 15 minutes early, and say before they get up on the roof, this is what the cost is. You had to be there anyway. It's the same cost. It was 15 minutes of your time. And if Mrs. Smith says, "I'm not interested," then you haven't. Then there is no performance. And more importantly, once you've already started pulling the roof off, there's no consideration for her promise. What were you going to do? Stop? Once you perform, after you've done performance, altering without giving additional consideration, there's no value for a contract.
But that's the thing. There is additional consideration because there are additional line items oftentimes, or there's additional costs. And so that's already been explained to the consumer. The only reason it's done in this way is so the consumer doesn't see, hey, the insurance company ripped me off. Now my ACV is potentially, $30,000 instead of 10, and I could have 20 extra thousand. I know I could hire somebody to do this work for the 12, and I don't really give a shit ultimately. And then this guy who has done all of this stuff for me and has scheduled the work and has delivered the materials, I don't really give a shit. Sorry, I hope things go well for you. But by doing it this way, it obligates them to at least let you do the roof portion of it. Right, and so, but that's not.
What you're saying is this allows you to snooker them into it. This allows you to do it so they can't back out, because if you give it to them beforehand,
they've already. Go ahead.
No, you've already just.
I'm gonna hop in here and say, no, not at all, not even a little bit. Has anyone snookered into anything? If anyone right now, in today's day and age, thinks that an insurance company doesn't owe them the Property Brothers price, then they don't understand how insurance premiums are calculated. They don't understand why homeowners are paying record amounts of premiums, yet insurers are making record amounts of profits during record disasters that are all simultaneously occurring. You haven't thought about it yet. So no, Tom, it's not anyone that's being snookered into anything, you lying, cock-sucking, fat sack of shit. No, that's not what's happening here, Tom. What's happening is a business is not being contractually interfered with in a tortious way, which creates a cause of action, right, toward bad faith and fraud on the count of people that we are then relying on in the future to give us a recommendation. No, we're taking that situation out of play in a smart business way from the beginning, to not let the cocksucking lawyers meddle their way into the middle of it and create a need for them to exist in claims that they want nothing to do with, right? 75,000 and under, you don't want anything to do with. Let's wait until the call goes on. Let's wait until we hear you talking about your $1 million claims that you're all of a sudden getting once you turn tail and run on any bit of any advice you said to me, right? So you could try to make me look bad, you fucking fat piece of shit. Lucky I don't come find you, Tom.
Because if I do it any other way, there's a chance that they back out, and I don't want them backing out.
Okay, so whose fault is that? Whose fault is that? If they had a righteous ACV from the beginning, then they should have the ability to pick. And so it's not my fault the insurance company requires that I put in 8 to 10 hours just doing the preparation stuff. But once all that's happened, the only protection that I have is the liquidated damages clause, because I don't know exactly how many hours it's going to take me in the initial phases to get everything where it needs to be to execute. But by the time it's to where it needs to be to execute, I have a significant investment of time and resources in this, and if they want to then back out at that time or leading up to that time, once I've shown them and provided them stuff that's proprietary or different things that I've had to figure out how to do and invest my business's time and take away from other clients, there's a significant opportunity cost involved in each and every single one of these claims. And when the insurance carriers have it set up to where they're paying 25 to 50% valuations on these losses, and then the insured only gets 60 to 80% of that, depending on how old their stuff is, then we have a huge problem where there's less than 25% of the project that's available in the front end for the work to ever have been done. And so if I then have provided a huge additional value because that's what should have been done from the beginning, I have to be able to protect that. And if the consumer is pitted against me inherently because they could make money by screwing me over, okay, I have to protect myself from that in some way. If you guys would make the insurance industry do what they're supposed to do, then it wouldn't be this way. But it's not unfair that I'm trying to protect my business. I've explained to the consumer that oftentimes these things go up by double, but I haven't invested the time and the resources in order to make that happen. And once I've done that, I want to guarantee that I'm getting a portion of the work. And so by doing it this way,
I got it too. I don't want the sales pitch.
No, well, I mean, I'm just telling you the justification for that you would have to defend it with.
If I brought that before the court, not only would I lose, he would turn it over to a prosecutor and have you prosecuted.
Again, just a lie straight through his lying ass, old fucking wrinkled balls teeth. Tom, no one likes you, right, dude? Nobody gives a shit what some old has-been piece of shit wants to say about what's true or what isn't. You lied, right? You had the opportunity to set yourself apart from all of this, and you lied through your fucking teeth just to make the badger money because you're a fucking coward. That's what you are. You are a coward bitch. And you brought the Russian people to my fucking event and you completely lied through your teeth there. And that's why I'm going to play it right after this. I don't give a shit about you. I have no loyalty toward someone who lied to benefit themselves at the expense of everyone else. No, go fuck yourself, Tom. Alright? You're not Uncle Tom at all. You're not even Tio Tomas. You're not the general, not even close. You're just a fucking old dude that nobody fucking likes, man. And that sucks because I liked you for a hot minute. I had respect for you for a hot minute. And that's not over. But today, with the stance you've taken against everyone for yourself, dude, go fuck yourself. Suck on a fucking fat dick over and over because that's what you deserve. That's it. You can dine with Badger all you want to dine with Badger. But at the end of the day, you're still just a low-life fucking scum sucking, ambulance chasing pussy. And I'm glad to say it. I'm glad to say it and see that smug look on your fucking coward face.
Under criminal charges, okay? Which you can't justify your wrong actions or your duress.
But that's the thing is you would give...
Let me finish.
Go ahead, sir.
You can't do these things based upon somebody else's bad conduct. Okay? And
so as you're going...
And the court would have looked at the consumer and said, this is really easy. This is really easy. If you don't like having to do all those things, charge them a fee for it. The one that will be upheld under the cons is going to be upheld.
Charge them a fee for it so we can get you on UFA.
Discussion. But or go to appraisal. You didn't have to rush off and put that roof on. You would have had some certainty. There would have been no uncertainty, zero. But
let the insurance company. Here's Tom's suggestion, right? So this is what Tom did to me. So this is not Tom's suggestion in general. Yeah, this is Tom's suggestion. Let an insurance company control 2 out of 3 parties in a 3-party arbitration. Meaning, in effect, right? Because the practical aspect is all we're really concerned about. Meaning, in effect, they control everything they need to control in order to say that no matter what you say, it was too much. Even if you said only the bare minimum slave labor was what was fair, and you were willing to accept, even though you were doing better work than anyone else, even though that was true, the insurance company can come back and say, no, you didn't deserve that. You didn't deserve that. You lying sack of low-down shit. Right? Because that's what you are. You're a lying sack of low-down shit. Isn't that right, Tom?
That's the thing, is they're initialing each and every item in there, and if they don't want you to do it, then the cost obviously comes out of the invoice, and the invoice isn't sent until they've consented to all the work. You're doing it in the tear-off, which has to be done anyway. Okay, the tear-off is, you tell the...
It doesn't have to be done during the tear-off. That's a false statement.
What do you mean?
Well,
the tear-off is going to happen anyway, and the insurance company has already said that the tear-off is included.
No, you didn't say that. You said that it could be for one slope, but not the whole slope. If the
what do you mean?
Company's already...
Yeah, they've already bought the whole job, and we're just talking about scope items that they're not saying need to be done, or undervaluing it, or undervaluing it by paying it in a demo rate versus a roofing labor rate.
I'm perfectly fine with that.
That's all I'm talking about. I'm not going to do it on causation stuff. Oh, no.
Okay.
If they haven't admitted to coverage on the item, I'm just talking about the scope of work to do the item. If it's a full roof replacement, and they haven't included painting the drip edge, we're going to probably go ahead and paint the drip edge.
Okay, so that's what I tried to explain earlier. There's a large picture scope, and then there's a minutia scope, okay? The large picture scope is all you have to satisfy in the beginning. They said the roof has to come off.
Right.
That's good. How the roof comes off is something we can argue about later. How much it costs to do that is something we can argue about later. What we can't argue about later is, no, the whole roof didn't need to come off, only half of it did. When I was talking about spoliation of evidence, I was talking about where they said only half the roof needed to come off. Okay? Because I can do a hypothetical exercise, which is what appraisal is, of what does it cost hypothetically to repair a roof of this nature with this many squares of this composition.
Yep.
And I don't care what you did. I don't care what the insurance company did. These appraisers sit down and say, the standard in the industry is this is what all the costs that are reasonably likely to be incurred. Yes, sure. in this geographic market, yes, we put in blank. Yes, we do it this way. Yes, we charge for this, and that's binding on both parties. So I don't have a problem there. The second part was about the cost. Dude, you can solve all of this. Just write in. If you want to do it first, just put in your damn contract. The price is going to be this, or
the appraised value.
The appraisal award or judgment, or a judgment.
Okay.
Sometimes, and then that way you can still do the same thing. Mrs. Smith has already agreed, and this is how much, because you're showing the RCV. And when she says, "Well, he told me I didn't have to pay all this unless it was paid," that's that next portion over here that says, "No, I only have to pay the appraisal award."
Right. Okay.
And,
Perfect.
and that one little, and then you're not in any of these problems. You don't have to explain why you took it off or anything. Just say she's protected. She's protected. Well, what happens if she didn't agree upon the price? Well, then she's protected by the appraisal award.
Yeah, and she's protected by the process that was supposed to protect her all along.
Right. And she's, or if she wants to pay out of her pocket, knock herself out. You know, those are uniquely her choices.
Yeah,
she doesn't.
Exactly.
You know, and then just here's the part that you got to remember, which is why I'm bearing down on you. Unfortunately, when you refer your sweet Mrs. Smith to me, I represent her.
I know.
And represent her, and that means I'm her dog. I bite everybody, and I don't want to be biting towards you.
I don't want you to have to bite me. I know. Well, you would if I put you in a position where you had to, and I would respect you for having done it, Tom, and that's okay.
Right.
You know, and I don't intend on putting. This is why I'm taking time out of my day when my girlfriend's been, you know, I'm standing out on my back deck.
Go. Stop talking to me. Call me when you got.
I'm back working tomorrow. Today was supposed to be my day off, but they've been kind of assaulting.
Stop talking to me. Go.
All right,
dude.
All right, I'll talk to you soon.
You can find 1,000 roofs. You can only find one good girlfriend. Bye.
That's true. Bye.
Bye.
Okay, so I looked at the appraisal clause. You are right. Look, dude, you can file that in a county court or any court of our record.
So
my suggestion.
Yeah, I mean, my thought is because they did it to us on Stefan's, and you know they're not worried about having an award set aside on account of it, and essentially they gave us what we wanted. Why wouldn't we just go try to have Judge Davis appointed by that same judge that did that one?
I can say you guys could do it. It just wouldn't be me. First of all, that judge. Look. I've stood up at conferences and say don't do that. So I can't do something I've said publicly, and I wouldn't do it morally either. But my suggestion is nothing stops you guys from doing it. And I would say if that's the way you're leaning, just have the client send me a letter, or I'll send the client a letter. I'm sorry, I wasn't of a service, and I'll give you a couple days. Then I just have.
Yeah, you'll notice what he does here is he backs completely out after he approached me, after he singled me out. Then he's all of a sudden getting $1 million deals where he's taking that 40% he talked about. Oh, that's not going to happen. Oh, wait, no. Talks about that in the next conversation. Talks about, oh, that's not going to happen anymore. But while it's going on, I'm going to give me a piece. Isn't that right, Tom? You fat little fucking pussy.
Tell the lawyer on the other side. It'd be easier if I was just tell the lawyer on the other side. Look, I no longer represent the client. They've terminated my services.
So
now, if that lawyer gets wind that you're going to be running somewhere, she's going to beat you to it and file something formally.
Okay.
And so I'm just saying, if that's the way you're leaning, the best bet is just ask the client to say terminate the relationship. That way, all I have to do is just call her up and say, my client's decided that they no longer want to move forward with me.
Okay.
And that way I don't have to answer anything from her. I don't have to tell her anything.
Okay.
Okay. I'm not under. All I can say is, look. If she says, "Well, what are they doing?" to say, all I know is they decided that my services weren't successful, and so this contract's up.
Yeah.
And if she says, "Well, what are they going to do?" Say, I have no idea. I can tell you, I'm not going to do anything.
Sure.
But if she thinks for 1 second that you guys are running someplace, she'll beat me to the punch.
I mean, I guess I don't understand how they beat us to the punch if we get a head start.
Well, because they're going to get a head start, because right now I have to first call her and say I'm no longer doing this.
Sure.
In other words, because and in it, I'll just say, in that letter, I'll say it appears that the judge doesn't by telling us to file, the judge is refusing to do what we've asked, which is the court's right.
Sure.
Okay. In other words, think of it as an informal thing. There are other things we do informally. If I ask the judge, will you marry my fiance and I, the judge can always say no. So because she's not required to. They're not required to pick an umpire. They're allowed to if they want to.
Sure.
And so how I'm going to read it is, look, this judge said no.
What do you mean? Like, so that's just like a possibility that anybody does.
Right. Because if you run to another judge, they're going to say, no, you should have still continued with this judge, the one I'm currently in front of. And what I want to say is, no, this judge has said no. We're not going to pursue it with this judge anymore. So now we're not I'm no longer pursuing or requesting an umpire.
So what has? I guess that's the question. Is this judge up here has said no, she won't appoint a judge?
No, this judge up here has said she won't do this informally. She wants us to e-file it.
Yeah, okay.
Which is the same thing as me saying, ma'am, I didn't ask if we could e-file it. I asked if you wanted to do it informally. So when you're saying, no, you have to e-file it, that's rejecting my request to do it informally.
Okay, and did she give any kind of reason for it?
No, the county actually, her court clerk says we don't accept these. You have to e-file this request, and that's just dead wrong. But instead of me calling up saying this is dead wrong, I just say, okay, the judge is not willing to do this informally.
Right.
Which is all I ask. And then now here's the reason why you want me gone. All right.
Uh-huh.
If you then run, if I say I still represent this client, and you run down someplace else, it's number one, I can't be involved in that. But number two, I have to tell the other side what we're doing.
Sure.
Okay. And I'm telling you, I don't do it that way. So how I do it is I just say I'm no longer involved.
Sure. Well,
okay?
And I definitely
and let me finish with the third thing. I'm sorry, Stephen.
Sorry.
The rule is you have to go to the first judge to ask. So you have to nix the first judge. In other words, even if you ran down the second, they could argue, no, that first judge still has standing. So I have to go nix the first judge. I have to basically say the judge has refused. That's why I keep saying that over and over. So I want it to be a clean playing field. That's
the rule. Is that something that I guess I could...
There is a case.
Okay.
There is a case that basically says that it goes with there have been, I think it was a Bastrop fire case.
Okay.
Years ago, and what basically happened is they went to one county, and while that judge was considering, somebody else went to the other county, and it was just a fucking mess, and they said, no, you can't go, it's before this judge, and so the general rule is, and look, it goes with the first judge that's approached. Until they've said no, that's the judge that appoints the umpire.
Okay.
Okay.
So technically this judge hasn't said no, they just haven't... Okay.
I'm going to say that this judge had. So in other words, and I'm saying I'm stepping back, I'm retracting it.
Okay.
So it's no longer sitting in front of the judge, and if I do nothing else, the judge is saying, I didn't ask the judge to do this formally. I asked the judge to do it informally, and when the judge said do it formally, that's the same thing as saying I will not do this informally.
Okay.
Which means they've refused to, which means, fine, I'm gone, I'm done, I'm out. I just need something from the client saying, thank you, Mr. Hamrick, we no longer need your services.
Okay.
And then I will then, when all rights, immediately call Thompson and Co. and say, I've got a letter from the client saying that they no longer need my services and they're no longer going to ask this particular judge. And then she's going to ask me the 20 questions. Well, what are they going to do? And say, I have no fucking idea.
Yeah.
Okay?
Well, so, it sounds like, I guess, is that, do you want to just be kind of done? Based on everything that's going on, I'm not trying to drag you into it.
I can't do what you want me to do.
Okay.
And so in other words, and it's not a judgment call, Stephen. I just can't and won't do it that way.
Well, I mean, but there are the ones in Dallas that we had talked about initially that you had. I mean, could we just take it away from this judge and go to one of the judges in Dallas then?
I could try to. I would suggest that you do it with the county court, but I would have to tell the other side that I'm doing it.
Right. Well, I mean, and that I don't think is that big of an issue. As long as everybody's aware, then everybody's aware. I mean, I guess my thought is, I don't really want to lose you as far as this, because I think you are kind of a buffer and at least something that gives us a little time anyway. But man,
I have another problem, because as soon as I tell the lady that I'm still representing them and I'm looking at other options, she's going to immediately file.
Okay.
It beat us to it. In other words, it takes her 1 second to file. E-filing happens instantly. I have to get in the fucking car, drive down, and it's easier just to say I'm not involved. And you know what? Going to the county court judge, you have decent clients. Just have Mr. Smith walk down, and he's just hand it to the clerk. He doesn't want to talk with the judge. Just say, would the judge please take a look at this?
Do you need to grab that?
No.
Okay.
It's a scam, likely.
Oh,
okay.
Yeah.
And I'll give you a form, and this says this is. They just fill in the form, and they go. There's only one county judge
in every county.
There's only one county court.
Okay.
Now like Dallas has 4 or 5. El Paso had 5.
I think Denton has like a couple, because it's always like county clerk or county court at law number 1 or something.
I think they only have 1.
Okay. Well, I guess I'll just look it up and see. I was trying to kind of wait. I got to talk to the clients tonight anyway. So let me touch base with Ed and Mary and see where they're at on it. And
I'm going to once again say that this might not be the best one, and I think you should just hire Justin. He's not going to get you. He's not going to get you everything that you want, but he's going to get you pretty dang close.
Yeah.
And look, he may not be able to get you 10 and 10 in overhead, but he'll get you the money under supervision. He'll figure out how to get it done. I just had one where he was the appraiser.
Sure.
He got 95% of what the guy was asking for.
Sure.
95%. Okay. It's just. Look. Wait till we get in, and soon I'll be able to do this. We'll be able to do it.
Uh-huh.
Denton is a tough fucking county.
Okay.
And I'm also worried about Judge Davis. Look, he's a nice guy, but he may end up being the judge from hell.
Yeah.
And he's also sitting on the bench in August.
Sure. Okay. Well.
Think about it.
I'll get with you tomorrow, okay?
All right, sounds good. Thanks, Stephen.
Thanks, Tom. Bye.
Bye.
What's important is you've heard a lot of good things. This is my opinion.
All right, so you hear Tom backing out. I'm not going to go ahead and play the next call that I have recorded, because at this point I'm recording calls with Tom. I don't record calls with my friends because my friends don't try to fuck me out of tens of thousands of dollars. But Tom, at this point, wasn't my friend. Tom left me hanging on this job, and to this day, 4 years later, after he negotiated a fraudulent, biased appraisal process on my behalf for me, and then weaseled his little bitch-ass, fucking squint-eyed ass out of the way of the damages that I would have brought toward him, and that are still coming back to him. I'm going to lay him right on his fucking lap and let him say sorry, or he can pay me for him. I don't care. He can pick. But that's not going to fly in my book. Nope. Not happening. No way. No how. Uncle Tom. Not going to work, buddy. Not going to work. Here's the dinner. Here's where Tom completely undermined Oscar Ortiz versus State Farm. Even you'll hear him say, oh, this does nothing relative to bad faith, does nothing relative to getting attorney's fees paid. Bullshit. And I'm going to show you while he's saying it in the actual case itself. Okay, so he doesn't want you to read it. He just wants you to take his word for it that it doesn't mean what I'm telling you it means. Because if it means that, then it means that we have fairness. On my mom's birthday, in June 28th of 2019, the same year that I started in all this, which is part of the incentive that I had to keep going. Because I'm like, that's got to be God telling me something, right? That's God saying, Stephen, keep going. You got it. I got you. And so I don't hate Tom. I hate that stupid ass smug look that's on his face right here, right? You should hate this too. You should hate that dumbass smug look on that dumbass face, right? Because that's not who he is. That is not Tom. That is Steve Badger Jr. And that's not who I would have told anybody to trust. And bullshit that he became that. And that's probably Badger's fucking arm around his shoulder right there. It just makes me so mad, right? But what are you gonna do? You gonna hate this guy forever? You gonna watch this old dude fight Steve Badger to the death? I mean, that's my favorite option that I've thought about. And that just came to me just now. But maybe him and Badger should fight to the death. And then whoever gets to live through that can't be a piece of shit anymore, otherwise they gotta die too. Because how many people did they push out of ancestral home with this strategy? How many Hurricane Harvey claims were unpaid at the time that an increase in premiums was levied upon those same people who didn't even have a home yet? At the same time, their ALE money ran out because they had a public adjuster that was being run by some dipshit like Tom. Thousands, hundreds of thousands, 95% times 1 million claims per year since 2005 in this state. Okay, so 18 years times 950,000 is a lot of families and a lot of assets that were purchased eventually for pennies on the dollar by people doing the same thing that Tom is recommending doing, only in a roundabout way, right? And it's sick. And it makes someone like me angry. And anger is a natural reaction to betrayal. So you can say that there's something wrong with me for taking offense to this, but I would say there's something wrong with you if you don't. And I'll argue that in court, and a jury will agree with me. So let's not make that necessary. All right? Let's say this is wrong. Tom, you could still say this is wrong. But if your ass gets to the courthouse steps, bet that I'm not letting you pull the rug out from underneath me at that point. You can bet that we're going to go in and we're going to see what a jury says. Alright? No offense, fat boy. But we are going to see. And you're not going to like it. Because you already know. And that's why you lied so hard, to try to get me completely away from what was true and what was reasonable and what was accurate. Because I had everything I needed without you. And you had to make yourself necessary only to then abandon me when I needed you. It was the worst level of betrayal that could have happened. And they counted on you. You're probably the only one that could have fooled me at that point, man. Good job. You got me. I'll tell you what, it left you with a big old hole, baby. Big old badger-sized hole. And if you're ready to eat all of that shit that he laid on your shoulders and think that you're not going to answer for it long in advance of you getting to claim that, oh, he gave me indemnity or this person gave me indemnity, therefore I don't have to answer for it, bullshit. You answer first because you're the proximate cause. Just because somebody told you to jump off the bridge doesn't mean you jump. Ignorance is not an excuse for an attorney, Tom. Shame.
That new case that allows you to say, or not, has nothing to do with you guys. We've already established, you don't make a penny on that, all right? Mrs. Smith's going to get a little bit of interest, and potentially the lawyer can get a lot more money, and potentially he's happy as hell to take your case and say, don't worry, I'm no longer charging 40%. Now think about it. Is he being gratuitous? If a lawyer charged 40% of the overall recovery, remember, even though it says lawyer's fees, those don't go to the lawyer. Mrs. Smith can say you're entitled to your interest, and Mrs. Smith, you're entitled to recover attorney's fees, so hopefully you can pay your attorney. Now, if a lawyer said, I'll do it on 40%, you think, oh. Mrs. Smith would be glad. She's going to get 200 something bucks. They're getting 130,000. Throw it in a pot, give them 40, give her 60. That's, do the math, guys.
Yeah.
They're not going to be doing that anymore. I'll be surprised if you see any more 40% contracts for about a month until the first court screws somebody or it turns out. And don't think Ortiz or Barber Technologies gave the lawyers a roadmap. It gave us a road sign. Head that way. And in this journey that way, what you're going to find is, so there's no premature celebration here. We just got pointed that way. I got to pass 40 different streets to figure out how this is going to work. All right? So, but I can tell you what it didn't do. At least what you can't cite the case for. Number one, and there's a difference between Stephen and I. I'm just saying what the case didn't say. Either way.
Yeah, Stephen doesn't lie, I do.
There's nothing in these two opinions that allows appraiser fees, expenses, or PA fees and expenses to be recovered from the insurer. Is it an open issue? Sure. It just wasn't part of the case. So understand how cases work. It would be like, I don't know, you guys are doing some construction work and the house doesn't have a gutter. It doesn't mean you guys will never fix gutters. It just means on this particular case there were no gutters. Cases are like that. They're fact specific. There was no request for an analysis about attorney's fees. Now that doesn't mean had they done it, the court would have awarded it or not. Those are open questions. If you ask me, you guys shouldn't care about it anyway, unless you're an appraiser or a PA. I wouldn't put out much hope. All right? So, all right. Let me just go over some real quick things that I'm asked every day. So let me just get them out of the way. If you already know them, just nod your head and say, come on, move along. All right? All right. Contractors may not advocate, discuss coverage or exclusions. Who hasn't heard that? Okay? It's true. You're not allowed to be advocates who talk about coverage and exclusions. Does that mean anything to you? Probably not. You know when you're talking about coverage and when you're not talking about coverage. So let me give you a couple more helpful things. Contractors may discuss the scope of work with the adjuster. Okay? Now, later on I'm going to ask you why you would want to do that. It's not like they listen to you. Okay? But you're allowed to discuss how I'm going to do this project. Contractor may discuss supplements and clarifications. Contractor may discuss the amount of damages, the appropriate repair method, or pricing method, but it has to be relevant to the estimation. So here's the bottom line. You guys your business is going to be to fix this problem. And when if the insurance company calls you and says, I have questions about how we're going to fix this problem, you just talk in a technical sense. I don't want to hear any of this, well, you're supposed to indemnify us. And you're supposed to, no, just talk. If two contractors were talking. No, we got to do
Don't
it this way.
Don't read the contract to enforce the contract, right?
Now,
That
here's what you're going to
Tom.
find. And we're going to segue into this. What happens when the adjuster disagrees with you about the proper method or the pricing? Do you think that there's as a matter of law, this has got to be how it's done? Anybody think that?
No.
Yes,
How
there is
something
actually.
is done is
Any reasonable
Very few
cost the
exceptions.
insured
There's
is
an
likely
opinion.
to incur.
Okay? So when you say that adjuster's lying, no, he's not. He's giving his opinion. Now, what do you do to opinionated
The
people? Do
lying
you argue with them?
opinion that he was trained to give.
Everybody's entitled to it. Does it make him a bad guy?
Not entitled to lie. That's
But it just
fraud.
means, look, you're not going to settle it. What are you going to do? Okay, and that's the purpose of this talk. What are your options? All right. Now, before we get there, I got two other things. I hear all the time, so let me just put this to rest. The insurer, that's the insurance company, is not obligated to pay a contractor directly or even name a contractor on the claim policyholder. It's not binding on them.
Agency theory, bitch.
It would be like if Stephen and one of you agreed at the end you're going to tell Hamrick to dance the jig. I was like, fuck you guys. You can't tell me. My obligation was to come here and speak. That's it.
You're dancing this damn jig, Tom.
No, I'm not. Trust me.
We agree. We agree that you're dancing the jig and you're just binding.
You sound like contractors. All right, so the second thing, the insurance obligation is only to the named insured in a mortgage company. Some insurance won't put your name because they're worried about misappropriation of funds. This is a nice way of saying, what if the contractor's a crook? That's just a bullshit reason. Why don't you just come out and say, we're not doing it because we don't have to? Okay, I don't need a reason after that. What you think, calling us crooks or saying, well, some of these people, it doesn't matter. You don't need a justification. It's a freaking contract. The policy between the insurance company and the insured is just like your contract with the insured. It's a contract. The insurance company can't come in and change your contract. You can't go change the insurance company's contract. You follow me?
Yep.
Okay. So
Just how well I know this, page 13 is where we're going to find this little
Go look
jam.
at the frequently asked questions section. Now, do we have any PAs in the room? Good people, by the way. And I promise I wasn't going to say
That's a
anything
good
bad
one.
about them.
That's Chris Cleveland, guys. If
Serious.
y'all don't know him, get to know him. That's a good guy.
They may be able to make me dance the others. But all right. Do you realize?
Make him dance.
Do you realize? While it is a true statement, contractor may not give the insured legal advice. You all know that, right? Query: may a PA give the insured legal advice? According, I don't disagree with you, but according to the Texas Department of Insurance, nope. So next time when you're being told you can't give legal advice to the insured, say, if I can't, PA can't, who can? But I'm not getting rich. I have to go through all of you guys.
Okay, so we're going to look at State Farm, or Oscar Ortiz versus State Farm real fast. And it's an important one, otherwise I wouldn't be drawing y'all's attention to something that sucks to really look at. But page 13, I was wrong. It's not a King's Act prohibiting any damages beyond what is owed if they do appraisal. And so that's what it says. But if we look back just a little bit, because Ortiz seeks no actual damages other than the policy benefits paid in accordance with the policy's appraisal provision, he may not maintain bad faith. Okay, so if and only if the bad faith results in the necessity of the appraisal expense having been incurred, then that is extra contractual. Okay? And they're leaving that open for them to argue, but they won't do it because the lawyers don't want this. Who wants it? One person in this state, and that's me. In spite of everything that I could have made by taking the side of those who don't give a fuck about justice, who don't give a shit about fairness, about how much you're paying in premiums, and if it makes sense that our legislators are accusing our governmental bodies of fraud and then not holding them to account for that. Meanwhile, any of us, the regular people, gets accused of something like that, it rips our whole life upside down. And even if we're just accused and not actually guilty, they have the ability to turn the whole community against us. And I just ask you, is that right? Do you want that for the people that are standing up for you, the only people that are standing up for you, the only person in this case that is competent enough, that God placed into this role, that learned this horrifying secret, right? And I learned it just like I said I did. It's not like I made this up. Jeremy Snyder, conversation, Facebook chat, February 1st of 2001, or sorry, this is right before I go out to Vegas. Right before, right? So 2/17, I text him, but I had texted Steve Patrick on the 1st. What did I say to him? You probably don't know me, but I knew him from the forums. But aside from Steve, Tony, and Edward, you're probably the most unquestionably consumer-sided authority in LTP, so thanks in advance for fighting a good fight for us. That's the reason I'm coming to you with something. I had a question. Why do none of them tell contractors to mention the proof of loss to customers? Not to tell them what to do, just send your bill, make sure it's fair and you can support it, then let insurance sit on it long enough to breach, pay or invoke appraisal if they don't think that's fair. No more discussing unless they call to ask a legitimate question, but it takes out the game. I just started reviewing the line items with the consumer when it was time to send in final invoice. Get their initials on each page saying they agree that these items seem reasonable and legitimate to them, and they are being billed accordingly. Then send proof of loss and we're done. Not saying PAs and appraiser aren't still needed, though they're not. But making the carrier invoke appraisal seems to make a lot more sense from my seat than explaining to the consumer why things like replacing drip edge, etc. might be necessary. Took my time to 20 to 40 hours admin work per claim back to a normal job time. Also, I'm deciding if I'll pursue a professional engineering certificate, PA license or law degree. From someone who's been a PA, do you think it would be very advantageous to have an engineering certification, or is it easy enough to get through without? So I was going to him from help. Didn't respond until I make a viral post. And then all of a sudden it's, hey, will you send me that viral post? Right? Didn't realize you would ask me for the PDF. I made it in Zoom notes on my iPad, but yeah, what's your email? You can have anything you want, buddy. Thank you, man. We should chat sometime. Would love to. That didn't happen. When can we chat? So I go out to Vegas and I find out they're all cahooting against us. They're all working against us. Working in negotiation on about 300 deals, though I never lift a hammer. They don't call me Martillo Blanco. I misspelled Wednesday because I only had to have a high school diploma to graduate, or to get my public adjuster's license. Oh, what's that? You have a degree in biology? Oh man, you're overqualified. It's not what happened. Right? And so this is the problem. The people that we're going to for help are the people that are leading us in the wrong direction on purpose because they've been allowed to be financially incentivized to do so. And that doesn't make sense for anyone except them. And it's no offense to them. You know, we kind of did it by allowing it to happen. But here you go. An insured who established the rights to benefits under the policy can recover those benefits as actual damages resulting from a statutory violation. Okay? So, there's one. If an insurer's wrongful denial of a valid claim for benefits results from or constitutes a statutory violation, such as prompt payment of claims, the resulting damages will necessarily include at least the amount of policy benefits wrongfully withheld, obviously. But is that all? Right? Is an unbiased appraisal process after they've already committed the fraud in bad faith for at minimum 60 days, is that all? And so that is the question that Josh Davis wasn't competent enough to ask. Because if he would have asked, he would have gotten attorney's fees and he would have gotten bad faith for the first time in 75 years. If this was 4 years ago, that's 79 years. Insurance companies haven't been acting in bad faith in 79 years. Oh, come on, y'all. Regardless of whether an insured is entitled to benefits under the policy, he may recover damages for a statutory violation that causes injury independent from the loss of benefits. Okay? So that's the important part. Independent injury. Exceeding what he was owed under the contract. Here the issue is not whether Ortiz had a right to benefits under his policy. Assuming he did, State Farm argues that, in light of the appraisal payment, Ortiz has received all of the policy benefits to which he is entitled, thus no outstanding benefits remain to be recovered as damages for any alleged violation of statute. Ortiz maintains that in addition to policy benefits, he is entitled to recover the fees and expenses related to the pursuit of those benefits, i.e. the appraisal process, which was only precipitated based on bad faith and fraud. If they didn't lie, we wouldn't have had to do this. If they didn't lie, I wouldn't have lost X amount of months in revenue potential from the business. But now that we're months or years later, yeah, I've got those damages. And that is in addition to what should have been paid under the contract. And that is what treble is calculated off of. Triple. That is what punitive triple is counted off of. It's not the original withheld amount, although that should be a consideration. But what's the consideration is, what is my loss of use that you guys unlawfully withheld? Ortiz maintains that in addition to policy benefits, he's entitled to recover the fees and expenses of pursuit necessitated by State Farm's unreasonable investigation, which is true. Just specifically, okay, so here is this. There are two aspects to the independent injury rule. First is that if an insurer's statutory violation causes an injury independent of the insured's right to recover policy benefits, the insured may recover damages for the injury even if the policy does not entitle the insured to receive benefits. Second is that an insurer's statutory violation does not permit the insured to recover any damages beyond policy benefits unless the violation causes an injury that is independent from the loss of benefits. So again, if you don't have the fraud and bad faith, you don't have to go to appraisal. They knew they owed from the beginning. and they denied it only because they have set up the laws by sending in their minions into our legislature to allow that to happen in order for them to be able to then rip the umbilical cord out from underneath any lawsuit on the courthouse steps and say the lawyer is going to take 40% and Mrs. Smith, as Tom keeps wanting to refer to her, and Mrs. Smith takes 60% of the loss value to her home. And then when she swore to that in her proof of loss, which the lawyers made her do, right, because she can't be coming back from war later, when she swore to that, that became fraud on Mrs. Smith. So in what world is that fair? That Mrs. Smith takes 60% in fraud and the lawyer walks with 40% a hero in Mrs. Smith's time of need. Sounds pretty fucking stupid. Judge. We cannot reconcile Ortiz's position with either Texas law or the nature of attorney's fees, entitling a prevailing plaintiff to recover actual damages plus court costs, and allows an award up to 3 times. However, the only actual damages Ortiz seeks are the policy benefits. He didn't seek the cost of appraisal. Okay? They put this in writing on purpose. It was conspicuous. They told us if we were paying attention, and then you're going to get to hear the rest of Tom saying, no, that's not what they said. Yeah, that's what they said, Tom. Stop lying, you fat bitch. To the extent Ortiz contends that the attorney's fees and costs he incurred in prosecuting the suit are part of the actual damages he is entitled to recover, we disagree. Texas law is clear that attorney's fees and costs are incurred in the prosecution or defense of a claim, though compensatory, in that they help make a claimant whole, are not damages. Okay, and that's true again. But let's go down here to the only note that matters on the bottom of page 11. At oral argument, Ortiz was asked to clarify the damages he seeks under Chapter 541. Counsel responded that he is seeking only attorney's fees and the treble damages, and expressly disclaimed any right to recover any appraisal costs or other expenses as damages under 541. That's the rub. This is how $250 billion are presently being stolen this year from the American middle and lower classes through paying double and triple insurance premiums on every auto, home, every insurance policy that exists. We're paying way overpriced. This is why. Loopholia. Don't call us America anymore until this is fixed. Call us loopholia, because that's what this is. We therefore do not address whether such costs are potentially recoverable as actual damages under the statute in the event evidence of bad faith is presented. They knew they had to pay the whole time, and they refused to do what was reasonable in someone's time of need after they knew they paid that in the past because it was reasonable in someone else's time of need. And they owed equity. They owed indemnification, good faith, and fair dealing. And they were being paid to provide that benefit. You don't get there doing it this way. That's bad faith. And it should have been awarded on my mom's birthday in 2019, 4 years ago. We'd be living in a different world today. But I guarantee you we will be soon, on account of what they've done since this, which is what? Which is sad. That's what it is. It's just sad. It's sad and wrong.
All right, so that's my little background, okay? That should be the 20 useless little pieces of information that you may put it in your back pocket. And if you have other things, I was wondering about X, we'll answer them later, all right? All right, let's talk about estimates. Look, and this doesn't mean to be a lecture on what you have to do. I want you to understand the importance of your estimate. What happens when you guys write an estimate? So there's the obvious answer, or maybe it's not obvious. Are you writing an estimate because that's a business tool for you, right? And I'm going to suggest to you, I'm not sure the estimate is a business tool for you. And let me ask you this, because we're going to get to it. In your contract, what role does your estimate play? Because that's not what I'm hearing. You're not saying I'm going to do this for my estimate. You're saying things like, God forbid, I'm going to do it for insurance proceeds, or I'm going to do it for the adjuster's final supplement. But I have not seen one yet that says I will only do this for the price of my estimate. Unless you're a Jew. Okay, so, but unless you're that man back there. My point is if it seems screwy, what business writes estimates that it says, but it's meaningless to me? And maybe it isn't meaningless because there's another reason to have an estimate. It's because it recognizes this is the scope of the work that we think needs to get done. All right? Now, is that for your benefit? You guys really need to make notes? You didn't write the estimate for that. Why did you give it to Mrs. Smith? You gave it to Mrs. Smith so she could give it to the insurance company. Not because she's agreed to pay you on your estimate, but because that's kind of, you guys think that's kind of it's a good thing. It's Mrs. Smith's way of saying, hey, there's something fishy here. My contractor says it has to be done for this price, but most importantly, how many times have you heard back of, look, when we went and adjusted, you didn't tell us about that fence. You didn't tell us about the outdoor patio stuff. Yeah, we didn't even look at the garage door. You never told us to look at the garage door, so we can't go to appraisal on it, and that's why it wasn't in the adjustment. And there's an easy way to put a stop to that. Well, you have my contractor's estimate. The contractor's estimate plays that role. That's one of the important roles. The unintended consequence. It's a way of putting the insurance company on notice of, hey, look at these things, and don't tell me you weren't told to. Now, your insurer doesn't have to learn, here, lady, write the following email. Hey, dipshit, look at these things, because I'm dead serious, please investigate it. They already know that, okay? And in fact, I'm going to tell you, most of the stuff that I see everybody write the adjuster is worthless. You know, please look at such and such, and I'll be at your back door at sundown, and you know, just send him the information, and you don't even have to say, do your job. What's he going to do? No, I'm on lunch hour. All right, so what's the last thing a lawyer ever tells somebody? I'm going to sue you.
Yeah.
Why? Well, what else the fuck you going to do?
He's a lawyer.
You know, I'm going to make your hamburger. You know,
please, medium rare.
That's the only thing I can do. I can only sue you. But we don't make those threats, okay? Because you look like a rookie. You know. Now, the final thing in communications, folks. In communications, those are often Exhibit A. Exhibit A in a lawsuit. And when you write these long, scathing, you didn't do this, and look, I get an appraisal demand letter, and it's 4 pages long. You know, we've determined that you haven't indemnified properly, and you've done this, and you've violated this, and you. What do you think the first thing they're going to do? Mrs. Smith, let me hand you Exhibit A. Did you go to law school? No. Is this your writing? No. Who told you to do that? Contractor, PA, or the appraiser. You don't need that. I'll send a form. It's like 3 lines. It doesn't start with, hey, asshole. It just says, you know.
It can.
We disagree with the amount of loss on such and such policy for such and such claim. Our appointed appraiser is, and make sure you have his phone number and contact information. And you don't appoint a company. A company's not an appraiser. Okay? There's a 1960s case that says, what the hell are you guys doing?
Again, you don't need to appoint an appraiser if there's nothing that is disputable relative to the scope of work that's going to be completed. And it's being completed according to the low median retail price per their own estimation software. You use Xactimate, which is what I recommended we do. We use their own software. Then there's no argument to be made anymore. It's they either pay or they invoke appraisal in bad faith. And then we get these damages that Oscar Ortiz said we get. And Tom is sitting up here telling everybody that we don't get. And Tom flipped the script. I called him 2 days after this when I had to pay about $3,000 out of my pocket for this dinner because, number one, it got switched on the day before from one place to another. Number two, log jam traffic on a Tuesday, which never happens. I mean, it rarely does, but it was 6:30. I was a half an hour late after leaving Denton an hour and 15 minutes in advance. So that means it took me an hour and 45 minutes to get 30 miles. That's traffic. And that is unusual for 6:30 or for 5:15 on going toward Dallas. Coming out of Dallas, yeah, but going toward? Come on. Okay? I mean, there's interference every step of the way when you stand in the way of blind, greedy prophets that put people last. And you can listen to my brother if you want to. Tell you about how you do all this for these people who don't give a fuck about you, instead of listening to the people that actually love you, that try to have you killed. Well, I can't say that for sure, you know. Although I did leave him gifts, and on my way to my other brother's house, someone did try to kill me, you know, threw a car jack out their sunroof at my windshield. If I hadn't seen it and swerved, probably would have gone through my sunroof and caused injury. And he called the cops on me for leaving gifts for his sons that I'd made. Slingshots, right? There's probably some relevance there, but it doesn't matter. What matters is this what should be happening or shouldn't? And if not, how do we resolve it? And that is all I cared about. That's all I was getting at this whole time. And Tom telling me appraisal was the intentional wrong thing to do on purpose. Thanks, Tom.
Our appraiser is these 45 other appraisers at XYZ company. No, you have to appoint an individual. Does it make a difference? It made a difference in 1962 when the award got tossed out, but I've never seen it again. Okay? And I'm not. If you want to have a course, which I don't know why you guys would want, because I don't think how many of you want to be appraisers? Like you don't have enough time building stuff. Anybody want to be an appraiser? Except for the appraisers that are in here in the PA's office. All right. So besides the three geeks in the back, which hey, geeks is a compliment. I happen to be a geek. All right. So I'm just telling you. What you need to hear, and I haven't gotten to, is, all right, fine, you've convinced us that we have some little things that we screw up or we don't do correctly. Why appraisal? What is this? You know, so let me ask this. What percentage of your claims that you're handling go like clockwork? And we'll talk about in a second what clockwork means. How many of them are, you know what, I may get 30 screwed up claims, but I got 50 good ones. They smooth through. We're not having any pushback because we always remember the crappy ones. So, raise a hand. How many think 80% of their business just floats through? 70, 60, 50, 40, 30. Come on, give me some hands here. 30.
5. No.
5.
Once in a while.
3.
Okay.
1 in 100.
So appraisal, obviously, is only relevant if you're having problems, right? An appraisal is a method to efficiently, cost-effectively, fairly, speedily. That's not my word.
Expeditiously.
No, the Court of Appeals used the word speedily. Okay? Speedily. Like triplet. That's not my word. It means fast. It's supposed to be fast, fair, and efficient. That's something we need to work on. But in theory, remember I said in theory, it's like lawyers are supposed to be good in theory. Okay? So it was designed over 125 years ago to take care of this crap. And everybody used to think, well, that's because the insurance company has what it takes. No, it's not. You live in a small town. There are only 3 guys that did contracting. They got sideways with the insurance company. They got to call one of the other guys and say, look, can you be the umpire? And he walks down and says, I know Bill. Bill, you know that cost in 1894 isn't 2 cents a shingle, it's $1. It's a penny a shingle, I don't know. But and it got resolved. And so think of in theory,
this is better called
what appraisal was supposed to be.
Better
didn't have to hire a lawyer. Didn't have to wait two years. Okay, Mrs. Smith got off your ass because I'll tell you something. I've never seen anybody lose a client once you're in appraisal because they know they're in the solution. Okay, clients get pissed off when they don't hear about a solution. What's taking so long? Oh, we're just fighting with the adjuster. Oh, we got to do this. Once you say, no, we're going to appraisal, I haven't lost a client yet. Okay? Because they stop bitching at you, they start bitching at me. Okay, we'll call the lawyer, if I'm necessary. All right, so. Here's when you're all going to have problems with. All right? What's a fair price? Anybody? What's the definition of a fair price?
What's it take?
Whatever the customer agrees with. What I'm willing to work for as a business.
I'm agreeing. That's a good thing. But now I'm going to ask you, what is a fair price technically in an insurance claim?
What somebody's willing to do it for.
No.
Okay, what he's going to get at is what the average is that, they can come up with. Bullshit. What's fair is what they built for in premiums. That's the only thing that's fair. If they're paying any less than what they billed for in premiums on average, then the premiums are too high. And so when the law says they have to bill for any reasonable cost an insured is likely to incur, and that is Texas Insurance Code 36.007 or 2301.052.055. When it says that, they don't get to pay less and say that that's good enough. No, Tom, you're wrong, dude. And you're wrong on purpose to benefit yourself in a clandestine way while telling all of us that you're in it for our benefit. No, fuck you, dude. You're not in it for our benefit. You're not in it for Mrs. Smith's benefit. You're in it for your blood-stained pockets because Mrs. Smith's family lost out on her home when she died. Right? She didn't get the life support she needed during Katrina, so she's gone. And her family had to sell her house to Bo Williamson for 22 cents on the dollar. Thanks, Tom. Thanks, Tom.
Mid-market, the customer and a homeowner and a contractor agree to.
Absolutely not. What did I say?
It's honest, I'm saying no.
The lowest price? No. The fair market value? That's close. Okay. The problem is, look, let's say when you guys walk out, one of your cars is missing and you have to go make a claim on it. There's other cars like it. We know what the fair market value to replace the car is because there's a market for them. Anybody ever bought a used roof? Any resale value on that thing? Anybody know how to do it? Because your actual cash value is this hypothetical thing of right before that hail hit, what could you have sold that roof for? Oh, you need to cut it off and sell it on the market? It doesn't exist. So why do you think you go through this bullshit, what you guys think is bullshit, of calculate the replacement cost value, subtract depreciation, you get the ACV? Why do you do that? You do it because that's the only method that they can think of. There's no, it's not an asset that's depreciated necessarily over time. There's only three ways. Is it a depreciated asset that has a book value? No. Mrs. Smith didn't put her roof on a depreciation schedule. Could she have? Sure, but she didn't. Is there a fair market? Can you go on the market and buy one? No. So the only way that they can figure out how to do actual cash value is you got to come with replacement cost value minus depreciation equals ACV. That's why you go through that stupid exercise. Okay, it's not stupid. No, but we were talking about price. Several times because you're not going to get it the first time. You're entitled, as far as price goes, in an insurance contract. Here we go. Ready? Any cost reasonably likely to be incurred to the lifetime quality repair. Any cost, reasonably likely to be incurred. Where's our Harvard mathematician at? All right, what is reasonably likely statistically? What has the highest probability in a distribution of a data? Average.
51%.
Right? So average means, now you're thinking, I'm not an average guy. I do quality work. Why should I be getting paid average? And the answer is, I don't care. This is an insurance contract. These are the rules. This is how we decided to play the game. Well, that's not fair. I don't care. These are the rules. You agreed to come and play the game. Okay? Well, my overhead is higher. I don't care. That's not how we agreed to play the game. If you don't want to be in the industry, get out. Okay? So that really comes to the crux of the question, which is, do you have a business model that can operate in this insurance model world? I just told you, it's not how any reasonable person would do business, right? You wouldn't walk and say, Mrs. Smith, I'd like to put on your roof, and she says, I don't know. Let me go ask 4 people, and you'll do it for whatever my 4 friends say. Okay. I like what the gentleman over here said. You want to hire me, you got to pay my price. And the answer is, you're in the wrong business. Well, your price does not matter to the insurance company except for when it hurts the insured. Because to get recoverable depreciation, they must show now that they pay their deductible, but they also spent up to the limit, so they have to show, if I said your claim is $30,000, and you got to show me in the end, including your deductible, you spent at least $30,000. Well, what if I spent 40? Don't care. What if I spent 28? You're screwed. Okay? So what it helps them is just part of the rules of the game. So I'm going to ask you again. Have you taken a hard look and said, I can't complain about these things in the present? Now, I know you guys are talking about we need to change things, we need to do A, B, C, and D. That's not the way I do business. I need to feed my family today. I'm all for, look, I know changes in the future. Making money is today. These are the rules today. And trust me, they're going to change tomorrow, and the next day, and the next day. I've been practicing for 30 years. Jesus, the longer I go, the harder it is. I got to relearn rules about every 4 years. All right? So, business model. So what is your business model? And the answer is, well, I imagine it has something to do with cash flow, right? Cash flow is king. So what is cash flow based upon? It's based upon two things: getting fairly paid, but also promptly paid, right? How long do I have to carry this on my books, right? The next thing that's probably important to you is, what's my administrative cost? Because trust me, when I'm carrying Mrs. Smith's roof, what is she doing? She's calling me every 15 minutes. I've got an administrative cost. Somebody has to answer the phone. Somebody has to do whatever other little dance that I've decided that our company has to do to get paid. Do we have supplementers? How many of you all use supplementers?
No.
Probably good honest people. I'd be curious to see, and I hope I'm not upsetting anybody, you need to look, is it cost effective? It may be, it may not be. I don't know. Everybody's business model is different. All right? Opportunity cost. Does everybody understand what opportunity cost is? Opportunity cost is when I was screwing with this, I wasn't making money and I missed the sale over here. That's different from lost sales. When I was screwing with the case and you had to go too long, somebody came and stole my client when they had to put the roof on. Those all go into your business model. So an ideal business model would probably say, let me get the most I can, the fastest I can, at the least cost. Okay, so appraisals, fast, fair, and efficient. In theory. Okay? That's what the talk today is going to be about. All right, so what is estimation? When you send an estimate, what is that? Is that a rock hard thing? Is that a reflection of your prices? Is it a reflection of the industry's prices? Is it hypothetical?
Yes. It depends.
An estimate is hypothetical, at least used within the insurance process. Okay, because remember I told you, they don't care what your price is. So what do they care about? When I say any cost reasonably likely to be incurred, it doesn't mean by you. It means in this hypothetical exercise, in this geographic region, what is the cost that's reasonably likely to be incurred? So how do you figure that out? I heard Chet over here. We're going to go to a college, we're going to get a bunch of people, we're going to take our own data, and we're going to show them. Okay? In 10 years, I'll come work for you, but what are you going to do tomorrow? All right? So, everybody use Exactivate. Everybody hate it? You like it?
Love it.
Both.
Well, right.
Love it and hate it.
Do you have to use Exactivate?
Absolutely not.
Nope.
Very good. So rock it. The TBI says on the one hand, you don't have to use a specific program, but you have to use one that's accepted, a method that's accepted as in the regular course of the industry.
Okay, there's a couple things here that we need to touch on real quick. One, Exactimate does not reveal from whom they got the survey pricing. So they could be all industry preferred contractors, quote unquote, giving them this low median pricing, which are the people who work for them in volume. They do 2,000 jobs at $2,000 a job. They're still making $4 million. Okay? And that is the way you have to look at it. That's not what they're billing in premiums. That's not fair to the consumer who is paying what they're billing in premiums month over month, and they will not challenge you in court. What they've done to me is they've gotten to my clients and gotten them to accept additional payment on top of what I'm going to pay my subcontractors in order to cut me out of the deal, because they don't want me talking about what the truth is. The truth is, the last claim I worked was 2021, right prior to my mom having a stroke from a vaccine that we were all told to take by our lawmakers, the people who care about us, swear an oath to defend us. And 5 days later, she had a stroke, and they wouldn't even write the word vaccine in her chart. So I've been taking care of my mom. But the last job that I worked started at $18,000, and because they are so afraid of court and so afraid of a bad faith precedent being set, that ended at $90,000. And they wouldn't take it up to $91,776, $95. And there's a reason for that. But they shorted me $1,200 at the end, because they're going to try to say to a jury come time for trial, oh, he's just trying to go for this extra $1,200. No, actually, the scope of work that ended up being required as a result of your bad faith and fraud was $123,000 per Xactimate, if billed appropriately and legally, the way the job has to be built in order for a contractor to not go out of business. So 123 compared to 91, fraud and going to jail for an adjuster as compared to not going to jail and not doing fraud. And that guy's been ready to sue since last May. And the only reason that I've held off, and I had this conversation with that client 2 weeks ago, is for that adjuster's sake. Because he goes to jail for doing this. And that's not necessarily fair to him for doing what he was trained to do. Although, fuck him for doing it and stealing people's homes and owning a big portion of past Christian, Mississippi now. And I found all of his land before I ever mentioned that we'll be coming for his little nest egg that he took from the Katrina victims, when he made sure to mention that, oh, I got into this after Katrina and that's why I care about people. I've seen it. Yeah, you stole their homes through doing this to them. They had to sell and you were right there to buy. Shame. Let's not go back there and bring that back up. Let's move on to something else. That's what I love to do. But we can always go back as far as we need to. And y'all need to remember that.
So how many of you were contractors before you were doing insurance claims? You were just regular contractors. How many of you guys wrote Xactimate estimates? You're the guy I would not want to hire. That means you got every penny. Every time I got somebody come in to see me, he pulled it out. He said, Don, we're going to write a contract up, but let's see here. He's got like 4 lines. That's how much it's going to cost you. Okay? And would that qualify? Probably.
Absolutely.
If it's accepted in the industry, do I recommend you do it? No. And why? Because I told you, you're playing in this game. There's a difference between you don't have to and you damn well better. Okay? There's lots of things you don't have to do. They're saying if you don't want to do it, don't worry about it. It'll screw your claim up, slow everything down, but you can do it. Okay? So I don't care if it's exactly whatever it is, but you need to find a program that everybody can live in and have expectations about. Is Xactimate pricing fair?
Maybe
Anybody?
some things, yeah, some things no.
Okay.
Depends.
All right. Okay. So here's the answer. We don't care. All right. The answer is, can you make a living learning how to price things correctly in the insurance rules? And can you make a living and still put on the product? Can you do that?
Yeah.
If your answer is no, go home.
Yeah.
Okay? And I use this example for a check. I said, has anybody ever done a government contract before? They suck, right?
Right.
Well, but you got to know what you're doing. But you don't get to go in and whine and who wins? The lowest price guy, right?
No.
Okay, the second lowest price.
No. Sometimes if
The brother-in-law.
trust me, it's not about.
I know. But what I'm saying is, before you did it, you had to learn it, correct?
Yes.
You have to qualify.
You get to qualify. And if you didn't, you're out.
You're out.
Right? Okay? You're in the same type of business. The whining of it ain't fair, blah, 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 I don't care. Okay? Well, I care about it. But this is the business you chose to be in. Just like if you decided to go into government contracting, you can't say, I don't like it, it's not fair. Well, don't go into government contracting. You've got to ask yourself, can we make money in this industry? And I can't answer that for you. One of the things that I think that appraisal might do for you is Well, and before we talk about that. How many of you think if you could just say it correctly, if you had the skill of a PA, and you could just say it correctly, and I'm not talking about the law, just if you just do it factually correct and say the right magic words, you're going to get it paid. Okay? And I'll give you a hint. Yeah. By the way, that's not what PAs do. So if you're under the impression they've got a secret code book, here, let me whisper the right words. All of a sudden, everybody falls over dead and they write a check. You're not giving your PAs enough credit. That's not what they do. Right? But what you do, if you're telling me that it doesn't matter how logical I am, then there are no magic words. Why the hell do you have supplementation then? You just told me it's worthless. Okay? Well, the answer is, well, maybe sometimes it isn't. And that's what I call the low-hanging fruit syndrome. All right? So if I have no evidence that this is what the insurance company does, but if I were going to play you, I would make you work for it, right? I'd hold back. You're going to spend some more time. You're going to spend some more money. Mrs. Smith's going to start getting pissed off. And Mrs. Smith doesn't care how much you get paid. What does Mrs. Smith care? If you looked her in the eye and said, I'll put the roof on. Okay? So who's the holdup here? Is it Mrs. Smith or you? The insurance company is just saying, it's death from 1,000 cuts. Okay? And so finally, your supplementer comes in and says, I got a little bit more. All right? And make no mistake, that was hard work. Then the guy knocks the door and says, well, do you want to go to appraisal? He says, well, you only got overhead and profit left. How much are you going to charge? He says, actually say, you're not worth it. He says, no shit, I'm not worth it. You went and took all the low-hanging fruit. If you just left alone, I was going to get that anyway. You're the one who screwed yourself. Okay? So it's are you doing yourself any favor? If I already told you there's no magic language, right? There's no magic words and there's no logic. What you basically did is you took the low-hanging fruit out of it and you spent money on it, and then you're going to have to go redo it again if you get the appraiser. You didn't do yourself any favors. That's free. In other words, you have said, what did you get? I got this. We were already going to get that. I got that. We were already going to get that. What didn't you get? Overhead and profit. I know. That's why you think it isn't profitable. You took everything away from me. That's a discussion for later. Just consider that. All right? Okay, so before we talk about, gosh, I'm going to go to appraisal, how did you guys start? Did you talk to Mrs. Smith and get her to sign on the back of a napkin, or do you have this thing called a contract? Rhetorical question. All right, here's my question. Is your contract killing you yet? Is your contract killing you? How many of you or your clients now have examinations under oath against them? Anybody heard of this? Yes. Okay. Why do you think they're getting examined? And by the way, I'm the one that they call and say, oh shit, what's an examination under oath and how much do you charge to represent Mrs. Smith? And I said, well, what happened? Well, the insurance company, we finally got them to say, yeah, we're going to put on the entire roof. Everybody goes, but we didn't agree upon price, so what did we do? And rightfully so, we put the roof on. And we said, now we want to go to appraisal. And the insurance company, they must have all gone to a seminar. They said, if they do that, they're idiots. Okay? And why? Because they look at some of your contracts. And with Mrs. Smith, you agreed to put the roof on for the adjuster's final estimate. Okay? Now, 30 years ago, that might have been good. Or you say insurance proceeds. Now you're getting closer. I got news for you. It doesn't matter what you put, they're still pushing. That's their new litigation. Now I know what all of you are thinking. That ain't me. We got a business lawyer. Okay, I paid a good lawyer to write this contract. And I have no doubt. That lawyer wrote a good binding contract. You want to know what else is binding? Two things. Marriage and a loaded gun. Okay? What do they have in common? Aside from that they can both kill you.
You can lose everything.
Binding isn't everything. So now you're bound. Bound to what? I shot the gun. Where did you shoot it? Okay? That's what your contract is. I hear it over and over. Well, it's got to be good. I paid a lawyer to look at it. He says, maybe it's binding, maybe it isn't. But did you put what you needed in it? Did you put that lawyer wrong? No, he's a business lawyer. You tell him what you want in it, and he'll make it binding. How am I supposed to know? I don't know. Okay? Now, here's both the good and the bad news. You're all going to have to go back and put some more language in your contracts anyway. Go fix that. Okay? I don't know how you fix it. The best I've seen so far, and I'm not representing to you that this is the right way. I'm saying it's better than contractors or adjuster's final estimate or insurance proceeds. It's a list. We will do it for adjuster's final estimate plus supplements, comma, appraisal award, comma, judgment, comma, whichever is greater. Okay? Now, I understand you're saying, yeah, that's easy for you to say. Try explaining that to Mrs. Smith. Or better yet, come tell my sales team how they're going to sell it. And my answer is, you're in the wrong industry. You got to. It's killing you. At least I see it killing you. They went to the seminar. I got Safeco and Liberty Mutual. I'm fighting every day on that. We ain't paying you. Okay? They got bad contracts. Yes? You see that?
Oh, I've got one that their policy language actually states replacement with new, like, kind, and quality materials. And they're still and that's an 80-year-old tower.
Yep.
There's no way of matching a new, like, kind, quality.
Okay, so how do we solve disputes like this? Okay, so hopefully I've shown you, in a roundabout way. We've talked about your contract problems. We've talked about that. Go see your business lawyer again. You got to put that thing about deductibles. I'm not here to tell you how to do it. That really is what a business lawyer can do. Bring in the statute that says don't get me put in jail. What am I supposed to put in here? Okay. Now, do you need to go to appraisal? I don't know. How many of you have had claims that went to appraisal? Hands up. Not okay. How many of you were happy when they got back? Okay. How many of you were unhappy because you didn't understand any cost reasonably likely to be incurred versus it's not your frickin' price? Okay. Now, let me suggest this to you. You're going to appraisal whether you like it or not 99% of the time. I started that way. You're going. If you give it to a lawyer, especially with this new case, they're not going to, why would an insurance company not want to go to appraisal once you sue them? It's their get out of jail free card. It's their, well, you ain't getting any bad faith out of this. We're going to appraisal. So let me see if your logic's good. When we don't go to appraisal, we get to ask a jury for it. We're going to get a better number. Really? Have y'all seen what our juries look like? They look like us. Okay, but they don't. But most of them have no subject matter expertise. So instead of having to convince 3 people, 2 out of 3, you got to convince 10 out of 12. And you want to know what a jury sounds like? My cousin fixes roofs. I really can't tell you, but those guys were off. But my cousin says it's $100 a square. In fact, my mother got one put on last week by my cousin. Okay, and it's dry without you even being there. Okay, you know how hard it is to set aside a jury award on a fact issue? Freaking hard. You want to know how easy it is to set aside an appraisal award? It's hard, but I've done it. Never yet set aside a jury award on a fact issue. Never once. Appraisal award, yes. So that's like impossible or damn near impossible, impossible. I'd rather be damn near impossible, okay? You say, well, it costs too much money. I don't know. What does it cost you guys to go to appraisal on a residential roof? Anybody even know?
Shouldn't be much. I've heard $1,500 to $3,500. I've heard people talk about
$2 to $3 grand.
How much is the delta for that ask?
$2 to $3 grand.
I tell people somewhere between 3 to 7% is a good average, whatever your loss is.
Okay, but hopefully not saying we're charging somewhere between 3 and 7. You're just saying
I'm just saying depends on where it falls, and that's what it depends on who your appraisals are and who your umpire is.
Depends on how much is in discrepancy, what the delta is.
Okay, so that's a fancy way of saying this is a big claim or a little claim. Okay? All right? Now, I train former judges to be umpires. Okay, and the first thing I did is I said, look, this is a residential roof. You're only deciding differences. Shouldn't take you any more than 2 hours. You say, call the ball. Sit them down and say, which first issue? Yes or no? Call the ball. Okay? And by calling the ball, there's no splitting the baby. Splitting the baby is when I see the big picture and I cut it in half. He's calling the ball. Yes, you're entitled to it. No, you're not entitled to it. Where'd you get your price? Where didn't you get your price? Okay? So those are things that you need to worry about. What you need to worry about is, do I have a good appraiser? Right? So if I told you you need to go find a lawyer, well, I'm assuming you're going to go find a good lawyer. Because let me tell you, lawyers are like contractors, and they're like appraisers, and they're like everybody else. We got screw-ups, fuck-ups. We've got great lawyers. We got terrible lawyers. It's the same. We're human beings. Do you know who your proper appraiser is? Not, I got one. Okay, this isn't just like pick a penny up. Okay, so how are you going to know if you have a good appraiser? And the answer is, call and talk to me, and that's a different talk of look, these are people who do it. A good appraiser on a residential roof may be the world's worst appraiser on a commercial roof. A guy who does commercial roofs, sorry, if you can get him to touch a residential roof, he may be terrible, because he's thinking, I can't really bill on this one. Okay? Look, everybody has their own specialties. PA. Okay, you don't need me on a residential roof unless it's a complex case. It's a title case. Okay? So you're not using me for my glittered tongue where I'm convincing the adjuster. I'm preserving your evidence. Appraisal is something that you should be thinking about. It's not what you guys think. How many have you heard, look, how many have you had to go up against, there's 3 guys that can always do this cheaper? Everybody heard that? I got news for you, there's a lot more than 3. Because what's an average? An average means it's here, right? That means I got people to the left, and I got people to the right, deviations, right? So when they tell you 3, you can smile at them and say, hell, 3, there's probably thousands. But on the other side, there's thousands of people who could do it more. And I already told you, I don't give a crap what the guy's charging. What is any cost reasonably likely to be incurred? Reasonably likely, likelihood is frequency, which means average. Okay? All right, so it's just, you're going to have to, I don't suggest you guys learn these things and be able to argue them, especially if you don't want to be appraisers. I'm telling you this because build your business model around them now. And yes, every now and then do we get a wang banger of a appraisal award? Yep. Okay? Are you going to build your business based on that? I hope not. That's an outlier. Okay? All right, so I've skipped all over this. Do you guys want me to go over deductibles?
I'll touch on it when I go. Let's go we got 9 minutes till 8, and I want to at least get 30 minutes of Q&A with you if I have it.
I'll sit down.
No.
Questions? Yes, sir.
One question, man. So you said that a lot of times lawyers feel like they're left holding the bag and figuring out how the homeowner is going to be able to get their roof done or
sure.
the project is that's been approved.
Right.
In my experience, it's never been the lawyer or the PA or anybody who's holding the bag at the end. It's the contractor. Yep. Either the PA and then the deal is on the back end, or they figure out how to make this happen.
I'm agreeing totally with you.
So, has there been anything that's happened with the new law, anything that's protect us as contractors, personal job, the PA's job, and people like that? Is there anything that's protecting us more to where we guarantee to get paid on something?
Yeah.
Because we're the ones bringing the customers in, we're the ones keeping the relationship and making everybody trust you and trust PAs. And, hey, look, try this PA, or we should go to appraisal. We're the ones pushing that, but we're the ones holding the bag at the end.
Okay, so
it sounds like, and nothing against you at all, but you were like, we worry about, us as lawyers worry about holding back at the end. There's never been that bag in my position where the lawyer's holding it. He's telling me, hey, I see their check that they got, I see the PA's check, and then I see what we're left with, maybe the homeowner holds it. So,
Okay, so
it seems like indemnification never actually happens in that scenario.
okay, so first of all, indemnification isn't for you.
I should have said that word.
It's for the client. And let me be a frank. What I said was I didn't want Mrs. Smith getting 40% taken out of her award, but there are other people. But your question is valid. So the first answer is, does a lawyer owe the contractor any duty? Technically, no. Is he in trouble if he puts the contractor before his client? Yep. Okay. Does that mean that he doesn't care about it? No, of course it does. Okay. And the final thing is, I've never seen a settlement yet that Mrs. Smith took without first talking to her contractor. Mrs. Smith doesn't put any frickin' money in her pocket. So she didn't just run off and settle this case and go, screw it, I'll take this money and I'm sure my contractor will do it. When I sit down with Mrs. Smith, she just looks at me doe-eyed and says, that's meaningless to me. Is my contractor willing to do it at this price? And you are correct that more often than not, everyone's trading on your bill. It's coming out of your pocket.
Say we said, like, y'all set your pricing at what we as the contractors say we can do it at. We say we can do it at, we get awarded that, then the fees get taken out. How are we able to complete that job in the scenario before?
That's not the way that was not my explanation. My explanation was you said your fee or whatever. Look, do you think a lawyer has any idea what the proper number is? No. He's never put a roof on in his life, and he's never done it. All he cares about, he has to look at his client and he says, Mrs. Smith, you're going to end up with X amount of money. Is that okay? She says, don't ask me, ask my contractor. I get on the phone. Mr. Contractor, is that enough money? He says, heck no. Mrs. Smith, your contractor said no. She says, we're not settling. I put it down. I call back an hour later. All right, she's now got this much. Mr. And most of the time I just bring the contractor with me because Mrs. Smith is looking to you. Now, but you had a much wider question and a very good question. Is there anything today that's going to help put a stop to that? And that was that long explanation I gave you about it's too early to tell, but it looks like lawyers, remember, I said there's a way for a lawyer to get his attorney's fees paid on this one sliver of a cause of action. And the truth is, in order to prove out that sliver, which is prompt pay, takes pretty much the same amount of energy as the entire case. They have similar issues. Are we liable? Well, I have to do all that work. It doesn't matter if it's bad faith or if it's prompt pay. And lawyers should be, and I fully expect you're going to find lawyers who say, dude, I'm not taking any part of that award. And by the way, I don't have to talk to you about how much that case is worth. We went to appraisal. I'm stuck with it. And, well, you shouldn't have gone to appraisal. It's in the law. It's what if the other side wants to go, the judge has got to make me go.
Say proceeding. Proceeding.
So kind of what
Proceeding. Sorry.
Yeah, no, I mean it was important for me to understand, so
Yeah.
I want them to know too.
So I'm with you.
kind of what I was going off with. So, like, we establish and cultivate that relationship with the homeowner. You know, bring in a PA, a lawyer, whatever we need to either like further our agenda or what needs to happen on that case.
Okay.
Is there anything that makes this new situation, because appraisal right now is an absolute shit show. You know, we're in 3 or 4 of them right now that I wish I never would have gotten into, knowing exactly how it's playing out.
There's no way you're going to get ever out of.
No, I mean that's a hypothetical, but we're in it and we're in it now. But is there anything that's going to be able to make up? And now the homeowners are looking at me like, in the world, we just do this, you know? Is there anything?
So, what's the answer? Yeah, appraisal makes them get out of it. Because why? Because if they invoke and then they try to bias appraisal, then you get the award overturned with a fair court. And then, in addition to your justified award, which gets your contractor paid fairly, because you had to wait, you get interest paid to you. And because they lied to you in order to facilitate all of that, that was fraud. And because they billed you for the stuff they didn't ever intend on paying 99% of the time, that was bad faith. And so, yeah, there was a way 4 years ago It just hasn't caught on yet. You're welcome, Tom. It's not staying that way. So you and Badger can lick each other's ball sack for all I care. But we're not leaving all of this damage that y'all caused undealt with.
New laws that's going to make it to where I can say, look, this is an avenue that I want you to go into that is possibly going to get to a better conclusion than what we could do if we just sit here and argue for 3 or 4 months on our own. Is there anything in that new law that I can tell them, look, this is something that I'm still going to be able to have this relationship 6 to 10 to 20 years from now, you know, other than absolutely getting the most I can out of this one claim and squashing that relationship and not having anything like happening afterwards.
So, is there an avenue? Yes, there's an avenue where the lawyer would say, I don't really need your contractor advising me. There's an avenue where I don't need a PA. We'll hire all that out and we're not going to take any part of it. But as opposed to, look, we have to take 40%. That's the only avenue. Is there an avenue? Is there a world that you're going to live in where you don't have to go to appraisal? Maybe. No. There's one exception. There's an exception of both sides decide that they don't want to go. There have been cases tried where there was no appraisal, because both sides shook their head and said, we're not going to get in that thing. Now, what do you think the odds of that happening again? Slim. Okay? So if the complaint is, I hate appraisal, can we do anything else? Appraisal decides what your price is. There's nothing else. Okay? Yes.
So, when you're talking about cost reasonably likely to be incurred, are you saying that the industry accepted interpretation of that is an average?
I'm saying I'm saying that when you look at, if you're telling me that you go and use Xactimate, what do you think Xactimate's price is?
Medium. No, it's a medium.
Low medium.
Medium, okay. Medium, average, and mode.
Yeah. That's not skewed to the left. That's not. Well, so if that's the case, then is appraisal not the way that we move the average up in the industry? And
okay, so yes. Okay. Will you be doing yourself a favor if you're getting paid better or paid more correctly? All right. Every time you guys see a claim or you help Mrs. Smith, what percentage do you think you guys handle? You don't. There are the hundreds, if not of the small roofers, that go off and do the job. There's the Mrs. Smith who doesn't even hire a roofer, says I'll take that money. All those little things go into the price. Okay? Is there hope to actually change it in the future? Maybe, but you got to get paid today. Okay? I'm not a hey, let's go to the legislature. That's a valid thing, but you're asking me what are the rules today? And again, unfortunately, if somebody tells you, don't worry, dude, we're going to take care of you, we're going to look at you, we care about the contractors more than the client, we protect our clients, we protect our contractors, run. As much as I like it, we're not allowed to. Yes.
So, you said that it's not the meeting of two minds, it's what's reasonably incurred.
Well, wait a minute. So, no, I didn't say it's not the meeting of two minds.
Well, I said it's whatever the contractor and the homeowner agreed to, which is the meeting of two minds. So, Texas Admin Code 5.9970 D&E says a person insured under the homeowners or dwelling policy are entitled to have their home repaired by the person of their choice.
Absolutely. You absolutely are. It doesn't say that the insurance company has to pay the person of your choice.
You commended us by saying that you wouldn't be here if you weren't at the top tier, because it's about 2 years before folks go out of business.
Right.
Somebody said 3 or 4, but let's say you've been in business 10.
Yep.
You're at the top 0.0001%. So that means you're 1 out of 10,000.
Yep.
So is it reasonable to think that that person would have a share of the market segment, of the total market?
Yeah. You would have a very small share. A very, very small share. Your
No. If you've been in business for 10 years, you're better than 999.
Okay, but you asked for a share of the market. Share is a percentage. Are you a better quality?
So if you've been in business that long, would it be reasonable to think that that person has a significant share of the market?
Absolutely not.
Would it be reasonable to think that they have some share of the market?
Well, you told me you're in business, so by definition you have to have some share.
So if you have some share of the market, that means you're getting business. So that means that by being in business, you're signing contracts. And if you're signing contracts at whatever price you're signing them at, wouldn't it be reasonable that your price would be a reasonable price?
Absolutely not, because the contracts that you're signing don't say, I'm going to do this work for my price.
Mine do.
Okay.
If they do.
Some certain.
Some
mine
do it.
Some certain. I give hard numbers.
And in those cases, would that price be reasonable? Because otherwise, then how would you have a share of the market?
Dude, I just told you.
Lucky.
No.
Whatever it is.
The market is this. There are guys who say, screw you. I always charge this price and I get it. I always do it. But I'm not the most frequent price. Okay? Or those guys over
here. But is
here.
it reasonable to think that he could get business?
Absolutely.
Yeah,
sure.
Absolutely.
Power remodeling gets $800.
Then is it reasonable to think if he wasn't doing business that he's going to end up with an insurance claim?
I don't know what that means.
Because that's a reasonable price.
No, it means absolutely not. Here is your bell curve. What all you've explained is, hey, I've been in business for 10 years. If you follow this statistical curve, I'm in business over here. So this must be the price. And the answer is statistically, heck no. You're not the most frequent. The most frequent price is here. No. Is it fair? No.
Not frequent.
It's not reasonable? Okay. So at this point, I can't argue with you. I can only quote you what the law says. And so if you have a problem with any cost reasonably likely, reasonably likely.
So if that guy's going out,
you're not reasonably
if there's
likely.
10,000 jobs in a year in one city.
Yep.
So here's the law, right? So this is what he absconds from. This lawyer fails to mention this entire time what the rules of the game are. Why would that be so? Each underwriting guideline used by an insurance company in writing, this one's for example workers' comp, must be sound, actuarially justified, or otherwise substantially commensurate with the contemplated risk. Okay, I guarantee you this law has been changed to make it to where this only applies to workers' comp in the last couple of years, because this was the one that I had cited. Okay, and so they have done everything they can do to wiggle their way out of accountability. It says 2007, okay, fine. Let's see what the other ones are, right? Personal automobile, residential property, same deal. Okay, who is the insurer? It's them. Okay, including TWIA under the FAIR plan. What does it say? What are the rules of the game? Each rule, standard, guideline, or practice, written, oral, electronic, that's used by an insurer or its agent must be. What is it? Consistent with how they are used to classify those risks that are accepted for the purpose of determining a rate. They're not determining a rate without paying overhead and profit. They can't, because then that's not reasonable. Then that's not legitimate, right? The insurer has to tell the state what the guidelines are. The OPI may obtain a copy of the guidelines. Must be sound, actuarially justified, or otherwise substantially commensurate with the contemplated risk, may not be unfairly discriminatory, meaning if they've paid it once under the same class of policy, if they don't pay it the next time, it's bad faith. Doesn't matter who the claim is represented by. Claimant representation, therefore, having been tracked at all, bad faith. Yet we're dealing with an industry whose claims departments are cooperating with one another while their advertising departments compete. They train them to say unreasonable things in a reasonable tone, and guys like Steve Patrick and Ed Faco train us to call them and ask them to do the right thing when they're trained not to. And what did the guy on Rafferty's claim say? He said, "I was trained how I was trained. I've neither defrauded nor anyone." Right? What was his name? Oh man, now I gotta look. TJ Lawrence was this guy's name. TJ Lawrence. I've neither defrauded nor defamed anyone. Yeah, he did. I've neither deceived nor defrauded. Yeah, you did. When you came out here and you acted like you didn't know what was up from the beginning. You said, "Oh, I guess you guys are going to ask for overhead and profit on this." Yeah. We're not going to ask. We're going to bill for it. Okay? There's a difference, I guess. But the difference is that one side of that knows that this job can't be built legally without it. And the other side of it thinks that it's up to y'all to be nice in order to pay a fair amount. When the law says you have to, meaning if you didn't, then that's your fault. And it's not our fault that you didn't charge enough. But looking at the premiums, you definitely did. And now you just don't want to pay it. And that's why you're making, oh, let's see. How did the carriers do in 2022? There's a misspelling there. Property and casualty insurance industry. Mid-2022. U.S. consolidated surplus over the 1 trillion mark for the first time. Oh, look at there. Isn't that great? Y'all love that. Love seeing it, right? Because it's not like there are record disasters going on right now, are there? So if there's record disasters, how does it make sense that there would be record profits? Okay? They say net income fell in the first half, driven by underwriting losses compared to underwriting gains last year. Okay, but let's look at how much that actually amounts to. That's the rub. Okay, because we're talking about hundreds of billions of dollars, right? So expense ratio, is that an important number? Right? So underwriting gain or loss. I haven't looked at this chart before. I was just pulling something out. But again, capital and surplus. This is $1 trillion in surplus. This is $989 billion extra that they're billing versus what they're paying out. And so it used to be that this was like 37. It was opposite of what this is, right? So investment earned versus realized losses. Okay, but then that doesn't account for the depreciation they're never paying out because they make it to where people can't actually build the jobs. And especially if you're on the coast and then your time runs out, And then the city comes knocking and says, hey, you only got half a roof on your house. You need to move. You're telling me this didn't happen when I saw it with the Harvey claims and with the Michael claims in Florida? I saw it. And 6 months later, years later for Harvey. There's tarps on the roofs and work has not begun. Why? Because there's a quasi-governmental agency putting profits ahead of people. Meaning our taxpayer dollars are allowing that to happen. And our taxpayer dollars don't consent to that. In general. This is why judges and attorneys cannot be allowed to make the law. There be no liberty if the power to make the law be not separated from the power to judge. There's your sign. Watch the rest of this. I'm sick of it.
And that guy's in business?
Yeah.
Obviously, he's getting at least one.
So?
So is it reasonable to think that whatever price he's signed is reasonable price?
No. Absolutely not. No. It's not reasonably likely. Okay.
Yeah, just move on. It's fine.
Let me start here.
It's a good. I'm with you, but it's not the way it works, unfortunately.
Free market economy.
Yep.
Basically, if you're willing to do it for a certain price and to get somebody to pay that price, that's good. But there'll be that many more people who are not willing to do it or are willing to undercut that price. And so it shifts the bell curve towards their direction.
I agree. I 100% agree.
And you're playing in the insurance market, and so you gotta play with
your price
what
is
you
more
got
of a
going on there.
I 100% agree. Yeah, 100%. But it's also reasonable to think that the customer at the very tail of the distribution is going to get jobs.
You're talking about
because Texas admin code says you can pick whoever you want. These folks, because the insurance company is paying for it, can pick whoever the heck they want. So it doesn't matter.
They can.
So they're going to end up with that guy.
He doesn't have to pay for it.
They don't have to pay that guy's price.
All right.
And that's unfortunate, but
we gotta
move on.
No, that's fair.
You say a roofer has a client, he says, this is my best friend, he's a billionaire, I'm going to put on this roof, and he's actually going to pay me. I'm going to be able to prove those suckers. I got $1 billion for this roof. And he's allowed to do this, and according to Chet, it's in the government code. You owe me $1 billion because I'm in business. I had one client. Nice try. It's not going to work.
Insure this glass of water for $1 million, would you?
But if he just had $1 billion client, he wouldn't have been in business for 10 years because he can't find that many billionaires.
It doesn't matter. It's the same as if you insure this glass of water for $1 million and I dump it out. They're not going to pay me $1 million because the value was never there. It doesn't matter.
That's one-off instance. A business in business for 10 years is not doing business with one-off instances.
All right, stop. We're gonna start passing the mic so we don't interrupt each other. So I'll let Tom talk, and then I'll bring the mic to whoever's talking. That way we don't get.
Does anybody have any other?
No. Keep going. This is good, but we just want to do it. Zach Fuller.
I'd like to. So last year, like two of my. This year, 70-80% are in appraisal. We've just been stonewalled by carriers, and the only way that we're able to achieve even close to what we need to build, our margins are going down, but even close to what we need to build is to go into appraisal because we're guaranteed some results. I've never had anything go into appraisal and not go up at least 20 or 30%. I don't know, I know great appraisers, but I don't know what the interior of an appraisal looks like. So can you walk us into, this is the inside of an appraiser.
All right, so.
I do, that's Wild West.
Let's go. We all want to know.
All right. There's been over 125 years of appraisal in Texas. We have over 120.
If it's up to Tom, what that's going to look like is Tom's going to guide you into that process, and then he's going to bail at the last second and allow the carrier's attorney to petition the same judge who refused to do it for you in your hometown That judge is going to refuse to do it for you. She's going to ask you, do you have the authority for this? And you're not going to know what authority is. You're going to look at her confused. And then the next time you could go appear in front of her in open court, you're going to have a warrant out for your arrest for a traffic violation that actually wasn't a crime, which is why Denton Municipal Court is going to refuse to allow that to go to trial. But you're not going to be able to go. You're going to send somebody on your behalf who is going to lie to you about what actually was said. You're going to lose out. You're going to withdraw. The next week, they're going to put their own person in there. The carriers are going to go to her directly, and she's going to appoint one of their people as the umpire. So then and there, 2 out of 3 people in this unbiased quote-unquote process that's supposed to be fast and cheap, which neither of is true, but this unbiased process, quote-unquote, is then prejudiced from the beginning by the insurer getting to pick who is the mediator. Who's paying the mediator's check 85% of the time? Does that have anything to do with their loyalty and how they then account for potential losses? Is having a judge who is beholden, quote unquote, to the judicial code of conduct, even beyond the courtroom, advantageous? Well, to the extent that they give a shit about the judicial conduct. But if there's seated judges that are willing to violate it, if they change the law that said that judges can only hold one spot in order for their cult to expand its influence without expanding its numbers, yeah, you got a pretty good idea that says what? It says, 1, we weren't paying enough attention, and 2, they're doing it on purpose. And these are our judges, and they're doing it on purpose.
Years worth of case law on it. Not all, but we only had a very small number of Texas Supreme Court cases, and as you just saw on Friday, the law goes like this, right? Your average lawyer has no freaking idea what the law on appraisal is. I've got a booklet on it like this thick. So if you want to know what goes on in appraisal, that there are rules, that there are common sense things that have to happen. There are arguments that you can make, there are arguments that you can't make, and do you want me to tell you all of them?
I just want an idea of how that process plays out.
Okay.
I've got a kind of roadmap that I'll give everybody, and he's let him answer for sure.
Send me an email, I'll send you a pamphlet. It's called Common Misconceptions in Appraisal. It's 30-something pages long.
39, yeah. You got that one?
Yes, yeah. If you send me an email, I'll send anybody a copy.
It's a PDF. It's super. It's awesome. It's all also available on his blog.
So, but
ever asked for a copy of the policy language? If not,
no. Hang on a second. They asked for a copy of the appraisal clause. Appraisal clause.
at the very least.
Right. Right. Because the appraisal clause is the charging document of when it says you have authority to do something. Your authority is wrapped up in the language of the appraisal clause. For example, how many of you have gone to appraisal with farmers?
Yeah, you point AAA as the umpire.
Right. Yep. But it's not just that. When 2 appraisers get up on a roof under a traditional appraisal, they get up there, the first one says, do you see any hail on this roof? And the other guy goes, do you mean, do you see any hail within the policy period? And the other guy says, shut the fuck up. If you say that, you're going to get overturned. They're not allowed to do that, and I get them overturned on that. So it's just in general, do you see any hail, and how much is it going to cost? Right. Okay, not do you see any hail in the policy period, all this hail whispering, that's old, that's new, that's for us lawyers to apply. Now, so you've learned it, you're confident, you get up on the roof in a AAA thing. All right, dude, you see any hail on this roof? He says, shut up. Farmer's policy just says, do you see any damage on this roof? What do you mean? Not just damage, you mean pigeon crop? Yep. Do I see, we're not allowed to do causation. Read the farmer's policy. Read the appraisal clause. You may not determine causation. Now the bigger thing though is, here's the dirty little secret. How do you calculate depreciation? Depreciation is called wear and tear. Let's just all agree. If you agree that depreciation is wear and tear, the guy says, how much wear and tear do you see up here? You say, oh, you mean in English. How much damage was caused by wear and tear? We're not allowed to do causation. You can't do a farmer's, you cannot do a farmer's appraisal. You can't. Okay? The reason why the Texas Supreme Court, State Farm Boards versus Johnson, shot down State Farm and said, if you're telling me that they can only go because they can't do causation, this is the Texas Supreme Court saying, how the hell are you doing an appraisal then? You could only appraise brand new roofs. You got to be able to determine depreciation, and depreciation by definition has an element of causation to it. Give me a break. We've been doing these for 125 years. Next. And then all the lawyers jumped up and said, oh, it's brand new law. And the Supreme Court's going, no, it's not. It's common sense. Okay, so, but there are 30 things that go wrong in an appraisal. It comes down to, you get me a room of people who say that they've done appraisals, including PAs. I'll give them, we can go through it. Some of them, look, the other guy is not answering my calls. I can't get a hold of you for 3 months. Common problem, right? Okay. Well, let's go get an umpire. Well, do I need him? No, because you should have got the umpire within the first 15 days under most policies. Yep. So you go get an umpire. And the umpire says, well, it says I can only look at what you guys are disputing. I don't know what your dispute is. And the other appraiser's going, ha ha ha, we haven't reached our disputes. Well, yeah, you have. Because there's case law that says, yes, that's the general rule. Umpires can only rule on matters of disagreement between the two appraisers. The exception is when the other side withdraws or deliberately refuses to act. Let me give you a prime example. All those people who went to McAllen. It was a great case. Now, do you guys know Medeiros and Aponcio? Somehow one of them got appointed as the umpire, the other one got appointed as the appraiser, and some policyholder, lawyer appraiser. And about 10 minutes into it, the guy said, this ain't fair, we're not going. We withdraw. We're taking our toys and going home. You know what they did? They said, fine. Here's our signed appraisal award. They were in federal court. They said, they can't do that. No. They paid them a little more than I think Poncio or Madero wanted. And they're nice guys. They didn't do anything wrong. And to their credit, but they came and said, well, the insurance appraiser was saying pay X. We paid X plus a little. So we must have been fair. And the federal court judge just said, rule number 1, you may not withdraw from appraisal. Rule number 2, if you withdraw from appraisal, the umpire and the other appraiser may issue a binding award. The same is true when you deliberately refuse to act. Okay? You're supposed to be fast. So if you're telling me they're not fast, the reason is because we don't have appraisers and umpires who will do their job, and we have to get better at that. Okay?
Right.
And we have to get better at it. Okay, so give me some of the things that are your pet peeves other than having to listen to the lawyers over here. Yes, ma'am.
So when we have an insured that is invoking a right to appraisal and the insurance company refuses to acknowledge it, even though you've called, you've sent the certified mail, your appraiser is now trying to contact, what is...
You call me.
Okay.
That's what I do
Is that considered a refusal to act, basically,
No,
on their
that's
side?
it's a refusal to go to appraisal.
Okay.
So
that should be automatic next step, just invoke you.
well, you don't invoke me. You,
Well,
You're invoked.
but, okay, but believe it or not, look, insurance companies sometimes play na. But here's a na example. You sent me an appraisal demand signed by the appraiser. You sent me an appraisal demand signed by the PA. And they're saying, no, it's got to be signed by, it says you or we, right? Remember I said you're not allowed to...
Same party of the policy.
You know, so it has to be the client has to do it. And you say, okay, fine, we wouldn't fix that, we sent it back in. And they're still not talking to me. And I said, well, did you ever send them an estimate? Well, maybe you do, maybe you don't. Do you have a State Farm policy? Yes. Did you send the estimate 10 days before you sent in the demand for appraisal? No. Nah. So when you send it to me, that's why I say, give me all the documents. Let me first figure out what's going on. Okay? Most of the time, you'll hear back from them and say things like this. Here are the ones I've gotten in the last month. We don't have to go to appraisal because you're a roofer or your contractor's already put on the roof. There's nothing to appraise. Does that sound like a good argument to you? No. It's not, because we're not arguing about the roof need to be put on. We're arguing about how much. I don't even have to go look at the roof, right? There's nothing to inspect. This is just a pricing problem. And it's also a methodology problem, right? I actually had an appraiser call. Unless you guys agree to our scope, we don't have to go to appraisal. Jesus Christ, State Farm Boys versus Johnson, that's been 10 years now. That was their argument. They're in California. So you don't argue with them, you just send it to me, okay? Or you send it to a lawyer. If they're small enough, I file them as what's called a declaratory judgment action. It goes like this: Dear Judge, please declare the rights and obligations between the parties and make these guys go to appraisal. In addition, Mrs. Smith had to hire me, so would you please compensate Mrs. Smith for the attorney's fees? They go to appraisal almost instantly, because when we fought about this 10 years ago, one of the first cases after State Farm versus Lloyd's was a case called Manhattas, which was my case. Farmers said, we think the Supreme Court was kidding because they found some damage. In your case, there's no damage, so we're not going. I said, really, that's not what the Supreme Court said. Well, the facts were so. So we took it up on appeal and go to appraisal. Okay? Deck actions are quick. And also, you know what happens to the deck? Once I get it out of the adjuster's hands. So when you ask, why would I want to go to appraisal? What's the first thing that happens? The adjuster's bye-bye. You don't have to argue with anymore. Well, supposedly. All right? So it gets yanked off the adjuster's desk. When I get involved, what happens? It's yanked off the adjuster's desk, and hello, I'm the attorney on the other side. We're sorry, we want to go to appraisal. But before we go to appraisal, how much does your client want? And this is the conversation that I have to have. I then call the contractor and say, do you have a bottom line? His answer is, my estimate is my bottom line. My answer is, fine, we're going to appraisal. You know, if they wanted to pay your bottom line, they wouldn't ask me, do you want to do it? Appraisal's not even, we want you to go do it. But many of them settled that way. Okay? Many of them, while we're fighting, they say, fine, we're going to go to appraisal, but we're not going to pay you. You know, we're not paying you, you're paying Mrs. Smith, but I understand. And so we start fighting. And a year later, I get paid. But unlike you guys, I'm not putting out shingles and paying crews. It's just little old me. Okay, so I have a pipeline, and they're profitable. It only works for the smaller cases. In the larger cases, what happens when you guys write an estimate and you say, Mrs. Smith's got $65,000 worth of damage. Can I file a deck action? Sure. But it's going to get yanked up in the federal court because they figure I'm going to have at least $10,000 in attorney's fees. State Farm is not domiciled in Texas, so we go to federal court. I don't mind federal court. What's the problem with that federal court? Federal court never, ever, ever, as a rule, awards attorney's fees. So I can't file a deck action. It's going to get yanked up in the federal court because I'm not going to get paid. Yep. 75. But it's 75 including the potential for attorney's fees. And remember, in Chaco was 11,000, 160,000. I'm surprised everyone doesn't get yanked up in the federal court. So we didn't do a bad faith, because now it's different. Remember, I said these recent cases. If you go to appraisal and everybody behaves and does it correctly, and they pay the award, you don't get bad faith. But we don't have that case. We have the case where we played by the rules. We asked to go to appraisal, and they said no. What do we do then? And what happens if later, okay, fine, we'll go? No, I've already caught you stealing. You're out in the parking lot, and you're saying, I'll pay for the can of soup. It doesn't work that way. So we file a prior notice of action letter. Everybody has to do it. Okay, so even if you run, you're saying, we're going to run this thing to our attorney, and he'll take care of it. As soon as you hand it to the attorney, he has to write a prior notice of action letter and wait 61 days. Okay? Then he has to file a lawsuit after the 61st day, and it takes another 50 days. It takes time to serve, time to get the citation issued, and they have the Monday following 20 days. Just figure 50 days. So now you're out 110 days before anything happens. And it's just, it takes time. I don't care. I do both suits. I file them, I'll do a deck action. Yes, sir.
Quick question. So, like, if we are setting a case up and we see that it's going to not go our way, favorably as a contractor on the first visit, is there things we need to do to kind of line things up to set up appraisal for you guys, or for you, or for whoever, the appraiser? Anything that's going to happen? Is there a timeline, a guideline that
I'm glad you asked
follow?
that.
If you see something is going the wrong way, we need to veer off in a separate direction?
Yes. Okay, so you've had beat in your head. You're not allowed to give legal advice to an insurer. What's the difference between this? Mrs. Smith, I think you should go to appraisal. You said, how do you set it up, right? Versus, look, I can't tell you how to go to appraisal, but let me share what's happened with my other clients. And you can pontificate and go over your experience all you want. You just can't say, and therefore I think you should go to appraisal. So the first thing we set it up is you're not setting it up. You're setting up the facts in which Mrs. Smith has to make a decision. Does she want to go?
But when something's presented to you, would you rather have it kind of laid out the way you need it, other than like us being like, hey, all right, this is our timeline and how we've done things, rather than you say, you filed things the right way, you filed your estimate in this amount of time? Because I don't know about anybody else's firm, but I don't know about appraisal, and I absolutely can't stand appraisal right now.
Understand.
The new things that are coming out sound great and amazing, but I want to not only protect, you guys and the appraisers and the PAs, but protect our assets.
It's my belief in this industry.
A horrifying example, but that happens
all the time. I didn't bring any business cards. I'm not here to solicit any business from you. I'm the last house on the block most of the time. You know where to find me.
Yeah, he's not here to solicit business. He's just here to direct our business in a poor, worst case scenario situation where we lose every single time, twice on Sunday, because we have no expert in this. If they get their way, we have no way to argue, and that's not good, no matter which way you slice it, because we are the ones who are on the front line, nobody else.
All right?
Thank you, Tom.
Hey, Tom, now you can eat.
Yeah, now you can eat full.
Hey, I agree on that, because reasonable price will dictate what we agree upon. So therefore, we're the contractor.
All right, guys. Again,
so if we all agree,
Tom gives us
$300. That's what it costs.
Tom gives us a really, really good perspective on one side or one opinion there. From my understanding, the guy that was going to come from Daly and Black agreed more with a slightly different interpretation of the Ortiz case. And so this is what I wanted to discuss with you guys, which is, okay, again, let me start with, nothing I'm going to give y'all is legal advice. Nothing that I say then could be legal advice, all right, or interpreted as legal advice. I'm not an attorney. I may or may not have plans to be that at one point, but it doesn't matter. I'm not an attorney. I can't give you legal advice. Don't listen to any of this as legal advice. Listen to this as information. All right, and so the one thing that Tom taught me that I didn't hear come out that I wanted to hear was the information of law versus the practice of law. And so when we hear that's UPPA, don't do that, as long as you're simply discussing factual information, 100% of the facts can be discussed by us, okay? So 100% of the facts is the scope of work. 100% of the facts includes everything that we have to do for that and why, okay? Why do we have to do this? Well, if a guy falls off that roof and gets himself hurt, my conscience, my company, and everything else depends on me having coverage to make sure that that guy is not going to be just laying there bleeding out and there's nothing anybody can do to take care of him. I mean, obviously, that's a horrifying example, but that happens. And when that guy either the roofing subcontractor or the general contractor, whoever is responsible for it. Oh, by the way, you can record this. Anybody, if you want to, you can go live. It may or may not be that valuable to you, but if it is, feel free. I didn't care. That was something that came in today. The original plan was that we were going to record this and we were going to have this available for other people, and then that wasn't allowed to happen. So let's just, as far as the Oscar Ortiz thing, let's go to that because that's the really cool thing and big thing. Okay, so the attorney's fees are in play, right, Cliff?
Correct.
Okay. The part of Ortiz that I saw that some people may or may not see still was the direct reference that they are not saying that appraisal fees are not independent injury. That attorney did not ask for that particular part. He asked for his attorney's fees based on the bad faith statute and the violation. Okay, so independent injury means that it's something other than the claim value. Okay, so this phone was damaged and it's worth a certain amount, but if I have to spend something in order to get you guys to pay that amount, then that's not what the claim value was. Okay, so the idea is, and it has to go up to the Supreme Court again to have it found out, because there will be differing and conflicting rulings in the lower courts. And so ultimately, until that happens, until this thing gets back in front of the Supreme Court, nobody will know. There will be different rulings on this stuff in the meantime, and then that will be the law of the land. But right now, all we know is that appraisal fees are not, supposedly, but I guarantee you there's going to be attorneys that start asking for, or that start putting appraisal fees there. And if you hire an attorney day one, okay, from now on, any claim that you have open or any claim that you're going to go with, I think the main thing that was cool about it is Barbara Tech said, as far as I know, the appraisal clause does not, or the appraisal process doesn't pause the prompt pay responsibility. And the reason that we need to do a proof of loss is because that's the written notice of the claim. And none of the prompt pay statutes, as far as my understanding go, start until you have filed written notice. So if you're telling somebody to call in their claim, you're not starting any prompt pay statutes. That's a huge thing for us because nobody understands. Everybody calls in the claim. They have to send it in writing. That's what the proof of loss is. Appraisal is the second part of this, and appraisal is so important because it determines the amount of the loss. Okay, it's precedent to filing suit, is what Tom says. Okay, and that's not something that he's going to disagree with. So anything that I am going to say to you guys that he disagrees with, I'm going to say he disagrees with it. Other than that, I've thought about all this stuff a lot, and to give y'all information, to give my clients information when I've gone to houses, that was always something I was scared to be practicing something by having given them an explanation of why this is a certain way. Okay, and so as far as the unlicensed practice of public adjusting goes, my understanding is it's a carve out, and so it's the same thing, same principles as the unauthorized practice of law, except for now the public adjusters have a limited ability to do just that. Okay, and that's interpreting, and as Tom said, not giving advice. And so we have to look at it from our businesses and from the practical aspects of who are the stakeholders that are going to be involved every single time. Okay, we are involved every single time, whoever the contractor of choosing is. The insured is the one who suffered the loss. Every single time those two are there. And so those interests, to me, had to be protected. All right. What's great about the attorney's fees being in play for us means that the attorney's fees can include the cost of appraisal. Okay, so attorney's fees being $140,000 on Menchaca, or whatever he said it was, that included the cost of that appraisal. That included the cost of any engineering, any engineers, all of these experts that we were taking on. That's the costs of appraisal. Okay, that's the attorney's fees. Okay. Add into that, if we take the one to Ortiz to mean that appraisal could be extra or independent injury, okay, that means independent injury is going to bring back bad faith, right? Maybe? Yeah. Independent injury would bring back bad faith, and you could get that. That's so the different sections of the insurance code are 541 and 542. 541 talks about bad faith. 542 is all the second prompt pay statutes. Okay, so this is Cliff Nikiasen, by the way. He's a really good attorney, really good man. He was invited to be here when the thing was going to be a little bit different format, and then we just decided to go this way. So that's the whole idea, is if we could get independent injury added back in, then we can start pointing at their bad faith to say this is why this thing was slowed down to this point. And so if they had to incur cost of appraisal related to the slowdown, okay, this independent injury, then that's what resulted in it. So the bad faith comes in. So it's going to be a lot easier to convince an insured to go if they're getting a benefit out of it that's extra contractual. They're getting money in their pocket for having to deal with it. And in addition to doing it, so there's two schools of thought that, as far as I'm aware, the attorneys have been on the phone all weekend for this. There's two schools of thought, as far as I know, is what they're gonna do. One is hand the claim. A lot of them, the Daily and Black guy is gonna say, hand us the claim day one, no matter what. Once it's gone through appraisal, they haven't complied with prompt pay, and our fees are gonna get paid, and so you'll not have lost anything on day 700 or on day 40, depending on how hard the insurance companies sticks their heels in the ground. You're going to get 100% of the job cost. Okay, you're going to get 100% of what you should have gotten on day one, but there was bad faith involved, and so maybe I don't, nobody knows how it's going to pan out, but maybe the whole thing ends up getting punitive damages paid on it until they quit doing it. Okay, so the things that we have to consider as business owners and stakeholders in this is, what is the legislature going to do if there's so many lawsuits? And that's why appraisal is still an extremely important thing to do, and it's not something that we have to have an attorney for. If you can float it, okay, and so it comes down to what's the costs of doing it one way versus the other. Okay, if we can get an appraiser and PAs and these people to handle this process for us, people that are experts in documenting this, and we don't have to mess with it, we can build more jobs. Why would that be good for us? Well, you can move on, and maybe you take 90% at day 65 after the appraisal is done, as opposed to 100% on day 700. Okay, so what's better for you? That's what you guys have to consider, because we do not have a fiduciary responsibility to our clients, as far as I know, and I don't think we do. I have a fiduciary responsibility to my business, though, and I do know that I have to protect my business by making the best decisions. It's why I never hired a PA attorney or an appraiser up to learning what a PA appraiser and attorney's roles really were, and then even then I still didn't do anything but appraisal up front, because that's the best decision for the business if the attorney's fees aren't available. If I need the cash flow to be here now, so I'm not stuck not doing anything. Okay, and so we have a big decision to make as far as that stuff goes, and it makes it tough when the carriers just, especially if they decide they don't want you in business anymore, and then they just quit paying the normal stuff, and then the low-hanging fruit no longer is at all in existence. It's just nothing. Okay, so all that stuff is pretty big. So I think Ortiz actually does bring 541 back into play, and I think we'll see that over time. And I think we have 26 months to make sure that we do come together, like Jack said, and that we do make it to where this can never go back to the way it was again, where there's abuses in this industry the way that we've all seen them, and that none of us understand the process that is basically the cause of whether or not, or the cause and the determination of how and when we get paid. Okay, we have to know, and we have to make these decisions collectively for our collective good, guys. And then let's see. So why can appraisal suck? Well, if the only people that know about appraisal are not teaching us about appraisal, and they're using it and they're telling us to do something differently than they would do, okay, because they don't call and they don't ask somebody to do something for them that's going to affect their ability to earn a living for their family. That's the only reason that you call a claims department, is say, where can you get it fast? How can we get it, up enough to make the ACV to where we can make it manageable and not have $2,000 to run a $30,000 job, and that's just the industry standard. Why am I here? Because the industry standard was not decided by our industry. My grandfather was a contractor in Dallas doing plumbing and HVAC work in the 50s and 60s, and the subs take 35% minimum, 50% often, and we take 10 and 10, and that is not enough. So what happens is we have to steal from the subcontractors. Okay, we're not paying them the number on that page. Who's paying exact prices to their roofing installers? Okay? Who thinks that's fair? It's not. These guys deserve to get paid what the labor rate is. And why would it be that Xactimate is calculated for a roofer that it's 108 a square for removal, but for a demo guy it's 45? 90% of that difference is the labor overhead, right?
Why? I mean, part of why that's fair is because they're assuming the internal roofing profit for the company. For them to acquire those jobs, and we're walking those jobs too.
Right.
So there's no overhead there with that company to acquire this job that we're walking to them. So we're taking part of that overhead and profit. But I mean, I'm sure all of us would if the margins for a general contractor weren't 10 and 10. Yeah, this business couldn't run off of 10 and 10. They'd close their doors.
Yeah, exactly.
20%, they'd sink.
Did you have something, Stephen?
Me?
Yeah.
You don't want me.
Okay, fine. That's fine. Honestly, I do, but just for the lack of time, I won't. We have 21 minutes, and so I don't want to.
Suggestion as far as the 10 and 10.
Sure.
Has everybody done a forensic analysis of your accounting?
Yeah, so that's something that I was going to get to, but yeah, we definitely. And that was something that I picked up from you when.
Pay it though.
Yeah.
How's that helping more than?
There are people. Let me just say real quick. There are people that are getting 50% overhead and profit on insurance jobs. Okay, that happens. That exists, and that is a thing. Yes, sir.
Hey, I've been a general contractor since 2007. I'm also an insurance adjuster. I've been an adjuster since 2012. All right, I'm an Xactimate certified trainer. Listen, guys, I got 35% back in 2007, and I was fighting Katrina. I don't know where this all came from. We didn't have Facebook back when I was a contractor. Okay, we didn't have that. But I had a really good PA that taught me how to fight carriers back in the day. Okay, and he taught me a lot of good information. And unfortunately, I went through a major divorce after 30 years, and I didn't want to pay my ex-wife at the time $5,000 a month. Well, I got out of being a GC. So I retired at a young age, and then I went back into being an adjuster. I thought I could change the world, just like Chris probably thought he could change the world. I was sadly mistaken, guys. I was on the phone with Kemper Insurance Company today. They're ex-CT, just like me. His exact words to me is he wishes that you guys would start learning how to write good estimates. Because the problem also is you guys aren't writing good estimates.
Sure.
Trust me, you're not.
Yeah.
I see them every day. But there is good PAs out there. There's good appraisers out there. There's good contractors. You guys just got to go to the next level. Okay?
Right.
I see it every day. I don't want to steal your fame.
No, and you wouldn't be were it not for the time constraints, and so I definitely appreciate the input. Was Robert and Stephen?
Just a quick hand raise, straw poll. How many of the contractors here write their own Xactimate estimates? Just a show of hands.
Good.
Okay, so that's pretty good for this group here, but I understand what you're talking about, and it's like, it just makes all the difference.
The people here know, for the most part, and they know that the majority of what I've said and what I've been saying has been the truth to the best of my knowledge, or the best of my ability. As I've learned it, I've gone on. Chris and then Stephen.
Just want to add on to that. So everybody here that writes their own Xactimate estimates, you know the RFG versus DMO. C3 is the first one that came out with the white paper on it. I was still an IA when they looked into it and started publishing, and I was the first one that they actually brought in to discuss it.
When was that?
This was what, 2016, 17, somewhere there, 16 or 17.
2016 or 17.
So, is everybody in here a roofer, or you just GCs? What do you do?
GCs. Well, roofing and flood.
When you do your Xactimate estimates, if you do RFG versus DMO, do you change anything other than your roofing, or are you just concentrating on
everything? Every trade. So that's the idea, and that's kind of what we're pushing is every trade should be accounted for by who's doing the work. Okay. The main thing for anything conducted at heights greater than 6 feet is the additional safety compliance things that we have to have, and so all of those really should be RFG. Okay, if you're talking about painting at an elevated height, it should be coded under RFG, and that accounts for the extra cost. Okay, putting on safety harnesses doesn't make sense to me. That's accounted for in the roofing labor. As it goes steeper, more safety precautions necessary, the price gets higher. But we need to make sure it's a roofing person that's doing it. Otherwise, you're never going to be able to afford, or the sub is never going to be able to afford the $80,000 in insurance or more per year that they're paying. What you got?
Give him first.
All right, so
I think Chris still needs to finish.
Yeah. You guys know how is the pricing in Xactimate Road? Full read.
it's supposed to be a survey pricing, right?
Yeah, but how is it road? How is Xactimate's pricing?
Fire and water losses, right?
RG DMO.
Wow.
See, there you guys go. You don't know what you don't know. Listen, I don't want to steal your steam, but listen.
You got it.
RG DMO is built on an average residential price.
Sure.
Average.
Sure.
So, how many commercial contractors we got here? Any? How many commercial contractors? How many custom home builders? How many above average contractors? If you're an above average contractor, should you be changing the GMO to RFG? Yes. If you're a commercial contractor, yes. I just had this discussion with Kemper today, just exactly what I was talking about. How about your true waste? How about if you guys are doing your true waste?
Calculate it.
Yeah.
No, it goes even beyond that, guys. Way beyond that.
Invoices.
No,
Are you talking
I'm
about?
not going to sell my class, but I'm just telling you.
Yeah, cool. Yeah, I'll put a link to it in the description for anything that we put here. I'll get you, Stephen. I mean, again, I don't
I'm here
think.
to help you, trust me.
I think you are.
Help, I told Jack, if you guys get in with Jack's stuff, right there, his group, hey, I'll be glad to come in and help that group. I'll tell you all the tricks. There's so many different things you guys are leaving money on the table. You guys have no idea.
Yep.
I mean, there's some very knowledgeable men in this group right here.
Right.
I know who they are. They know who I am. Right?
Hey, Steve, one question real quick. If we do change and we get approved for RFG from DMO, are we liable and actually obligated to have workman's comp?
I mean, so here's the thing.
It's likely.
Right. So again, your invoice is the only thing that, in my mind, that the carrier would ever reasonably likely see. So if you're going to spend all that time and effort and then go to appraisal and say that's something that's going on and bill for it based on those things, I would hope that you would do it, or I would hope that you would have your subs doing it. But you know, they wouldn't have the right to ask for that or subpoena that, as far as I know. And so I don't think that. Yeah, go.
Right, look, carriers hire me all the time.
Sure that you got workman's comp. If you get RFG on an estimate, because he said everything's changing in Texas.
Good.
So he said, if
good.
you got approved for RFG on removal, then make sure that you have paid those labor rates for work and have workman's comp to back that up.
I'm good with that. Well, I absolutely, I want everybody to have the right insurance. I think that's a good thing.
Necessary for us to be able to receive RFG, we have to be able to also compensate for workers' comp.
I've had carriers in Florida call me up. Their attorneys called me up and said, "Hey, Mr. Harmon, you reviewed the contractor's information." I said, "Okay, fine." First thing I do, guys, I go to your websites. I go to see if you're a commercial contractor, above average contractor. Who am I to tell you you're an above average contractor? I don't know. But I can see the quality of your work you've done. If you're only a roofer, a gutter, and a window person, and I don't see you scratching dirt, building up a building, and putting a foundation in, I don't know if you're an above average contractor. Okay? The next thing I'm going to look at your GMO and RG. How many of them did you change? Did you just change the roofing, or did you change all the trades?
Sure.
Next thing I'm going to look at, and I'm going to make a recommendation, did you change your 10 and 10? What is 10 and 10?
Nothing.
Is that for Texas? Or is that
nationwide?
The whole country?
Thank you.
That's the whole country, guys, 10 and 10.
Yep.
Are you an above average contractor? So when I sit there and I look at your file, and I see commercial roofing, I see custom homes.
10 seconds.
I see an above average price as 15 and 20. I see an
5
analysis
seconds.
from somebody to come in. I can say, you know what, Mr. Carrier, they deserve it.
Thank you.
Okay? RG, DMO.
You brought up two really good things, and I definitely thank you for your participation. So, one thing that I think is really important for us to know that he brought up is these policies cross state lines, but the laws don't. Okay? So the policies, we'll see very, very similar language across the country, and so these concepts don't just come from here or stay here. We have over 1 million claims per year in this state, every year since 2014. Okay, so what that means is the cases go up to the Supreme Court more often because there are more of them. Now there's about to be a ton of them, and they're going to use the frequency of cases to get legislative reform because there's so many cases. But why? Why are there so many cases that are going to come? It's because so frequently that they're underpaid in the ways that they're underpaid. It's not because, people just want to sue and that the lawyers are just charging money for it. No, it's because they underpay these things in my personal experience by 100%. They're doubly low. They've paid half or less every single time. I out of respect to them, I'm going to just cut you off for just a little while, and then if we have some time once I finish, I'll go. My notes closed.
Hey, can I tell you what I told all the certified trainers at exactly
Please, real quick.
Guys, listen, I challenged every certified trainer this year. There's 39 of us out there in this country. I challenged every one of them to start training their adjusters. I got booted out of 2 carriers this year. I'm banded by 5, okay? I asked all you guys, all contractors, if you don't have a certified adjuster, use an Xactimate. Ask them to leave the job, okay? If they don't know what they're doing in the system, how can they properly write you an estimate? And I'm telling you, I got booed on a bunch of carriers' sites. A lot of adjusters don't like me, okay? I'm not here to make them left or right. I'm here to teach you as an estimate, okay?
Sure.
That's what I believe.
Thanks, man. Okay, so...
I've got a secondary argument I use to get people motivated.
Great. We'll get to them. But again, so legislative reform that we need, guys. All right, we need uniform language in the appraisal clause, and that needs to be across the country because that does, again, cross state lines. They need help in Florida right now. Citizens they make them agree to the terms of the appraisal. Now, appraisal clause is in there the same way it is, but they have to both sides agree to the terms. So they'll say, yeah, we'll appraise coverage A, but we're not going to do B and C. And by the way, the left slope, we're not going to touch that in appraisal. So, and so you can determine the amount of the loss, but you've waived your right to appraise these other things. What's your experience with that, John?
It's called a memorandum of appraisal.
Okay, horrifying for the client. It is absolutely the worst possible thing if the carrier gets to decide what they're going to do. Okay.
Some carriers like TWIA actually do have a memorandum that you have to follow if you want to go to appraisal.
And TWIA, I think there's a law that was at least being talked about when I was down there.
Rule
28.
Right.
26.
Yeah, I've done 2 TWIA appraisals and I'm not going to do any more.
And so they.
For a long time anyway.
Right, and so for the same reason that they need help with that, here real quick guys, we need to get AAA out of these, Farmers, Germania, Texas Farm Bureau, I think there are a couple other companies. AAA gets all of their business, or 99% of the business, from the insurance carriers, and so there's an interest there. And so the way that appraisals are set aside, and Tom said they're nearly impossible to set aside, but I've heard a different story from him in the past as far as the difficulty in doing that. And so, it was odd to hear him say near impossible versus impossible, where I've heard, I get it all the time, they just always come with a non-disclosure agreement, an NDA. So for me, that just is, again, Tom is protecting Tom's trade, which is attorneys, and you expect him to. He has a fiduciary responsibility to his trade over contractors, okay? He is looking out for the industry and looking out for us, because us knowing our job makes his job easier. And if every time appraisal has to happen, and if it can get these things taken care of without us, then it should potentially be taken care of without us. Okay, and so when people say UPPA to stop you from doing what you should be doing, which is discussing the facts, that's a big thing, okay? And so understand that Badger's emailed to Tom this morning, and Tom talks to Badger all the time because Tom's trying to get Badger to understand the other side, but Badger will never answer anything in writing, number one, that he doesn't want us to know, because Badger didn't say that. And then Badger's, I've never heard anything from Badger. Everybody is worried about getting served a cease and desist. The guy's never picked up the phone. The closest I've ever been to him is when he got up from the seat and I was down in Austin testifying in the Senate. I was hoping he was going to stay there. I was going to put my arm around him. But it's not a thing. There's no one anywhere. I mean, it's a statute, and it is a statute that is going to take legislative reform to get not a statute anymore. But if we could just come together long enough to say, hey, this 26 months was a lot better until something messed it up. Maybe something's going to mess it up, and a lower court ruling is then going to result in court saying, oh yeah, an appraisal, whatever it says, and it makes it to where we can't utilize this stuff as well as we can right this moment. Right this moment is, if you can afford it, my suggestion would be hand it off to the most trusted attorney you know. You know a really good one, you know another good one here in Cliff. I bet you can find a recommendation on who to do it, but if you can get them especially quickly to appraisal, or leverage the knowledge of that and call the adjuster and say, what are you guys doing? Here's what we now know, and here's where this thing's going to go, and do you want to pay now this much, or do you want to do this other later and have us work it out that way? I'd rather just be done. I don't want to talk to you ever again, so can we figure something out? Okay, what is negotiating an insurance claim? All right, they can't tell us. They can't say what negotiating is. They can't tell us they can't give us a specific action to avoid. I asked Badger on numerous occasions, hey, what are the specific actions that contractors need to avoid to not negotiate the claim? There's
play nice.
Yeah, play nice. That's literally what he said. In Vegas, John Sailing said, play nice. What are the actions? And he can't say anything. You can't define it, because it would then prove that negotiating a claim is discussing the facts, and free speech is legal in all 50 states in the same way that discussing the facts. Right. So we're talking cost, causation, and scope. All of those fall within the responsibilities of the contractor. The only thing that we can't do is determine coverage based on coverage dispute. So if coverage has been extended, or even they haven't paid anything, but they've said, yeah, you got some soft metal damage, that's going to be about $12 that we're going to pay out on it. Okay, there's coverage. All right, how much coverage? That's the question that appraisal answers. The amount of the loss is what's answered by the appraisal. If there's collateral damage consistent with hail there, go to appraisal and have a judge, is my opinion, because judges have an additional, that's why Tom wanted to do judges, and that's why I think, we can do quid pro quo type deals, this for that, you do my services and I'll do yours, but it has to be the deal for the services, and there has to be money changing hands, and I would say at least $100. All right, so I pay you $100, you pay me $100, or you pay somebody else in a network $100. It doesn't matter. You just have to have somebody that you can do it, and for the first little while, you better tread softly and make sure that you're not going to handcuff yourself or the client and tie it up in litigation. That's the last thing you want. What I was looking for when I started out in this was a quick, easy solution, or something to where we didn't have to spend 90 days, 180 days waiting on the carriers to finally, for us to say the magic words. Magic word is, you're not going to convince them. Okay, you can't convince somebody to do something that their job depends on them doing, and I don't blame them for telling us no for that reason. Okay, we should be getting along with the adjusters. They should be finding ways to extend coverage, but instead it turns into them finding ways to exclude coverage because that's what their boss told them to do. Well, the homeowners are our bosses, and so what should we be trying to do? We should be trying to protect the value of the property. John, do you have anything you wanted to add, or go ahead? Sure.
Like, we all came here and lawyers, PAs, everything to figure out a way to make appraisal work.
Certainly.
How do we make appraisal appealing to the homeowner?
Right, so.
It's not open, right?
Yeah.
So you have to convince them to do that.
Yep.
How do we do that?
Okay, so if they hire an attorney, the appraisal's free, so that's number one. That is, and we know that per that ruling, or per that opinion rather, that's what they're saying. That's what's likely to happen. So if you hire an attorney, you got the fees. Okay, so that's why the attorneys, and that's why the Daily Black guy was going to say, day one of dispute, as soon as you have their estimate back and it's not what yours will be, go low, or go with it. Okay, because that right there is going to cause a prompt pay violation because they didn't attempt to effectuate the settlement of the claim in good faith quickly. Okay, promptly enough. Okay. What?
After the first claim,
After the first day. Oh, we're talking the adjuster, their adjuster has given a report to the client, and that's not what yours is going to say? Attorney. That's what that guy was going to say. Okay? Where my...
Other than saying, hey, look, there's 9 other dudes that are going to make this happen in the next month. And
Can I answer that?
Whatever.
Sure.
How do you make this?
I tell you how I make it appealing. This is what my vision is anyway. We all have to tell.
Well, that's not happening right now, bro.
But it's not. I hear you,
but right now, how do we
but
make
I'll tell you what I do. I
Result.
walked in and said the same thing that you said. There's 100 other people out there that will do it. If you want me to do your move, I'm going to do you a quality job.
Okay.
If you do this,
so that brings it.
Absolutely not covering deductibles, but to go to appraisal.
Right. So he's saying that, and that's a good point. So let me come back to it. Methodology, and this is another thing that didn't come out. Okay, and this is something that we all need to understand really, really well. When that house was built, there was a certain methodology followed. Okay. That methodology is included in the like, kind, and quality that they owe for, okay? So you have to know that. There were permits pulled, there was insurance carried by that home builder, custom home builder, okay? So what do you do to support it? Badger says, well, even Tom says getting estimates is fine for determining the value, right? Okay, so what do? Go to home builders and get the estimates and find out what they would charge to replace just this roof or to do just this water loss or whatever it is. Go to a home builder and find out. They're not going to do it. They're going to say, no, hell no. Let me pay $500 just to find out what you would charge if you could do it. I know that your opportunity cost to take it on.
To the homeowner, other than just getting it.
Right. So once you have that data, right? So I have a process through Tom, right, that I've learned that's the way to do appraisal. There's steps along the way, and my plan is to publish that after this. And then my responsibility to our industry is going to be done. Okay? This is what I'm going to close with, guys, and we're going to get out of here because I promised these people we weren't going to keep them too late, and they close at 9. My responsibility, once I learned that everybody else who knew what I knew didn't stick around with us and tell us, was I didn't want somebody else to be in my shoes not knowing that. Okay? So you guys, through whatever avenue, either my business page or my personal page or the Facebook group, through whatever it was, I felt like I needed to get this message and process out. And so we've got it. We've got the solution. There's always going to be some changes that are open to interpretation, and there's always going to be the court's ruling on certain things, but we needed this baseline information. And what you guys got to know now is y'all are smart enough to know I'm not crazy. I may be good crazy, just a little, and that probably is their fault. But I'm not crazy in the sense that the stuff that I say is not coherent and makes sense, okay? Some people have been led to believe that that's not true, okay? We are the ones who know this, and are we gonna then are we gonna use that just as our market advantage, or are we gonna say, this is not okay anymore to be the industry standard? Should we set a new industry standard that we've decided on? Should we come together and form a roofing contractors association that's for the roofing contractors, or demand that the ones that exist for the roofing contractors and don't go down to Austin and support PA bills that are not in support, or that make us put mandatory language in our contract? So if you do a roof and you are working with an insurance contract in any way, any contractor, sorry guys, y'all too, if you have an insurance restoration contract that's tied to an insurance claim and you don't have the new language in your contract, on August 30th, that is legal. On September 1st, that's a Class A misdemeanor, and you're looking at a year in jail and $2,000 in penalty. Okay? And there is no notice requirement for them to tell anyone at all. It's a criminal offense for you to put that in there, or to not have language on your contract. Why the hell is Badger down there telling us what we need to put in our contract? It's because we haven't decided collectively what needs to be in there, and said, why do you think the plumbers were able to turn this thing over? Why do you think the plumbers were at risk? The number one cause for insurance, or an insurance claim in Texas, is a pipe burst.
Oh, really?
It's a pipe burst. Wow. We have expansive clay soils that moves. We have underground copper plumbing. They break, okay? And they would do a lot better if they could make a MRP that charges 10% of what a licensed guy who has 8,000 hours of training has to get, or has to charge to cover their expenses and that knowledge and the liability. Because remember, at the end of the day, who's responsible? Okay, are you guys responsible, or is the insurance company responsible for the quality of work? Are you guys responsible, or is the insurance company responsible for the guys that may or may not fall? Are you guys responsible, or is the homeowner going to take that on, or should they have to take on that extra liability because they suffered a loss? Okay, we're talking, when I went to Florida, I don't know if you guys watch that stuff, we're talking people that don't have anything rebuilt or even touched. They have roofs completely ripped off. We don't deal with the severity there, but again, they don't have anything without an expert there, and their experts have decided, instead of doing their claims and making a decision I made when I had 43 and said, that's more than I really want to manage now, I better stop taking new jobs, and so I stopped taking new jobs. They've got guys with 12, 15, 20,000 claims. They take the ACV money and they go buy people's houses for pennies on the dollar, their own clients included, save the rights to the insurance claim. Then in 4, 6 months, maybe 2 years, they got a $40 to $60 million accounts receivable set up. So their attorneys that are going to collect all those claims are chomping at the bit, and they won't even represent the clients that they're then trying to sue when they breach. When they say, I'm not going to use you guys, it's been 9 months, I no longer have ALE coverage, I'm living in a tent or in a camper that's not tied to the ground, and we're in hurricane season again, so I'm not going to use you guys because y'all didn't ever do anything, the estimate's not even sent, and I hired you in January and it's June, okay? And then they get sued. And then the PA will never endorse that check, so there's hundreds of thousands of dollars that are just sitting there. This is one example of many abuses that happen in this industry when we're not all working together. What happened with these laws in Texas is we are all on the same team. The team that we are on became the same team that the first party guys were on. The problem is everybody thought we were on the same team the whole time. Okay? To everybody else that's not looking from the inside out, it looks like, the attorneys, PAs, contractors, and appraisers, they're all on the same side. But when we are looking out for our individual interests, we have to look out for the contractors and the insureds first, right? As the industry, because if we can't do the work for that money, then does the work get done? No. Yeah. What? Yeah, it still does. What if it doesn't? What if there's not? What if they put a roof on for $120K and then they did $40,000 in mitigation for $90,000, and then all that's left to do the entire interior restoration is $6,000 from the studs to the inside? How are they going to do that? They're going to sell the house to the PA for 10 grand, right?
I guarantee you the claim gets closed and opens.
Okay, so what happens? They lost. The people who were supposed to be protected lost, and that's why I wasn't okay with us not having the way forward as a massive, and the masses. All right, the deck page of the policy needs to be changed and include this dispute resolutions and discuss how this happens. We can do this if we decide that it's important enough to us for our grandmother to have a chance if we're not there, because the people that are abused in this the most are the elderly and the minorities. All right. That's the facts. The longer you stay with an insurance company, the more your loyalty is rewarded with maltreatment, because if you haven't left yet, you more than likely won't. That's not how I operate my life. It's not how I operate my business. And it's why I'm standing up here after 5 months of fighting this fight when I asked God on Saturday when I realized what these new laws meant. And why did this Dalian Black guy have bad faith written next to the Oscar Ortiz case, yet Tom doesn't discuss that bad faith is an opportunity, punitive damages are in the mix? That guy was going to tell us that, okay, but I got into it online with a Noble PA, and that guy probably had pull with that lawyer firm, and so that guy didn't show up. He didn't tell us that, because they don't want it to be common knowledge. But what we're going to do, we're going to save this information, we're going to summarize it, make it palatable for the average, we're going to give it to the insureds, we're going to give it to all the contractors that are smart enough to go look for it, and then people are going to have skin in the game in order to get full access to everything. But then as long as you have skin in the game, then you'll protect the information. And my idea was you can't just go out haphazard and not know, because you end up in a situation where if you're like me, you care, then you can't do it long term. And if you're not like me and you don't care, then you can do it, but you're working for pennies on the dollar of what you should be working for. There's $2 grand in the claim, and then there's nothing Yeah, exactly. There's nothing to go. You had anything to add at all?
No, well, I guess, Mr. my name's Clifford Nickies, and I'm a policyholder attorney. I use, only first-party property claims, and, I'll keep it short because we already went through, a lot of like Mr. Hamrick went through a lot of the legal stuff, but I wanted to echo something Jack said, and also Stephen, that, we just need to push back. I mean, I think, I forget, your name, but you said that, the adjuster just ignored the request for appraisal. Send it to an attorney. I mean, it doesn't have to be me, it doesn't have to be Tom, but somebody, a competent first-party coverage attorney. Before this all began, I was talking with Jack about it. I was down in Houston for a deposition of an adjuster on a Harvey claim. It's a concrete tile roof, and I had never seen this in an estimate before. But he had my contractor's estimate had a generator. And the insurance adjuster was like, "Oh no, that's ridiculous. You can just use the homeowner's energy." Well, no, it's not. Like, why does the customer need to, support it? That needs to be paid. So everybody needs to put a generator in their estimate. As long as it's valid, put it in there. And we need to just start pushing back and not settle. And that's really why I'm here. And I'll just kind of leave it at that.
In your experience, as a policyholder attorney, obviously. Not that people.
We give me your background a little bit.
When the homeowner approaches you, when you establish that working relationship with the homeowner, they have been conditioned to enlist your services somehow. Do you have any tidbits of what works to have to advise or to lay out what facts encourage a homeowner to enlist your services? How do you make that palatable and appealing to them?
For one, most people don't have a copy of their policy just sitting around, but in every insurance policy in Texas, there's a consumer bill of rights portion. It's the first part of the policy, and it says, "A, you have a right to sue your insurance company. This is from the DDI. This isn't made up by lawyers."
It actually was made up by lawyers, and it's garbage. We're so close to the end there. I'm just gonna cut it off, guys. It's almost 4 hours. I'm gonna have to break this up into several parts already. So I've had this since July 2nd of almost 4 years ago. And I let them save face at my expense, knowing that that's what they would do, right? So who's fighting for us out there? Who's still going? I agree, I jump around, but it's not because I stopped caring about this stuff. It's because there was so much else. Do we care? Do we care that somebody has what they need when their chips are down? Otherwise, let's get rid of insurance. Let's just let everybody wing it. Let's defund the courts. Let's go wild, wild west. But if y'all don't want to live in that world, and I certainly don't, then we have responsibilities. And they start by paying attention. The price of freedom is eternal vigilance. We don't get any off days from allowing this stuff to potentially happen, because it will. It has. History has told us that this is what they do. These are who they are. And I can understand the incentive when no one's looking. So it's our responsibility to look and stop this from happening, because they don't like it any more than we do. Steve Patrick told me, "Thank you," all caps, when I posted in his forum in a way that threatened his business, because he doesn't sleep well at night, knowing what's going on. Take that for what it's worth.